Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice John Englander. To my left, your right is Justice Maureen Walsh. We'll be the panel for all 7 cases today. As you know, if you've been to the Appeals Court, each side gets 15 minutes to argue. There's no rebuttal. We have read your briefs. We've looked at the record. We're going to have a lot of questions for you in many of the cases. So I would encourage you to get right to the heart of your argument. We don't need a recitation of the facts or the procedural background. With that, I will call the first case, which is postponed from last week, 24P 638, Innovation Pharmaceuticals Incorporated versus Cummings Properties Limited. Mr. Dwyer.
Good morning, Your Honors. Daniel Dwyer for the plaintiff appellant. With me was Mary Petronio. Your Honors, I would like to get right to the heart of my argument, but there's a small matter of appendix citations that somewhere along the way I would like to take time to correct for the court, and I think it might be best if I do that right off the top. My opening brief, page 18, halfway down, there is an ID site. It should be volume 1, 822. Page 23 at the top, there's a site that says 843 to 840. It should be 843 to 845.
Which page was that?
23 at the top. Page 38 at the top, instead of saying page 842, it should say 843. The testimony went over. And page 40 at the top, the site should be to page 837, not 593.
Can you reduce that to writing?
I beg your pardon?
Can you reduce that to writing?
Yes, Your Honor.
Thank you.
Gladly. Thank you. All right. Your Honors, the chief defect with the trial court's decision is that the trial court did not take into account any of the undiluted, unimpeached testimony from Cummings itself that on the basis of the writings delivered by Innovation Pharmaceuticals, Cummings understood that its tenant wanted to move to 80% less space, wanted to give back its laboratory, and so on and so forth, all the things that are recited.
So you're asking us to take into account that Joseph Martin from Cummings actually and reasonably understood from the emails that IPI intended, at least at that time, to leave at the end of the lease. Why shouldn't we also consider that whether Martin reasonably understood that if that was IPI's final decision, IPI would give notice in accordance with the terms of the lease, which the judge found IPI had been reminded of at the February 13th, I believe it was, meeting.
Yes, Your Honor. Because the deviation in the means of delivery of the notice is immaterial in the facts of this case, as in Spine Frontier and as in Sourcing Unlimited.
Cannot the notice has to be given with reasonable certainty.
Yes,
Cannot the manner of notice be relevant to the degree of certainty with which it's reasonably received? In other words, if IPI gives Cummings a notice, scrawled on a yellow sticky that says we're leaving, that's not quite the same as a notice delivered on paper, certified or registered mail that recites some of the things in the that are required by the lease. And doesn't that, following those formalities, give a measure of definiteness and certainty on top of the content of the message? And can't Cummings take that into account reasonably in saying, all right, is this IPI's final decision? We know currently they intend to leave, but is that definite? Couldn't they change their mind between now and the end of the, I guess there are another 6 weeks left on the period for them to make a decision?
All right. There are 2 questions there, and may I take the second first?
Well, I can't remember what the second one is.
The second was, could they have changed their mind?
Okay.
It doesn't matter if they had changed their mind. Once notice is delivered, if notice in a 300-day period, if notice were delivered on day 150, notice would be good. It doesn't have to be re-delivered to confirm that the tenant has not changed its mind on day 151,
Okay,
52,
but
and so
could
forth.
IPI change its mind and say, well, we know we said 30 days ago that we intended to leave, but we've changed our mind?
IPI would be stuck.
And we didn't send you, and we only told you that in a meeting or sent you that in an informal email. We didn't give you notice in accordance with the notice provisions of the lease. Now we're giving you that formal notice by registered mail, and this is our final decision. We're staying.
Okay, again, two things there. If they had done it, I want to address first the sequence and time. If they had changed their mind and given the best form of notice they could later on, if the first notice was sufficient, the second notice wouldn't count. Because
Okay, fair enough. But the problem you have is Sourcing Unlimited says if we're going to deviate from the language of the lease as to how the notice is supposed to be given, it has to be clear, timely, and unambiguous. And I think what Judge Sachs is asking you is, what if it's ambiguous, all right? What if there's some ambiguity to it, even though you say, okay, well, and this is your interpretation, by the way, not necessarily the judge's, of how it was understood by Mr. Martin. Because when I read what Mr. Martin says, he's saying, I understood it was their intent at the time.
well, I think I just beg your pardon.
You know, what's unambiguous under those circumstances?
Well,
Am I citing you the right standard?
no, you are not, Your Honor.
What
I'm
is
not.
reasonably certain?
Isn't that what Sourcing Unlimited said?
It does say, but Sourcing Unlimited is a summary judgment case, and we do not need to carry a summary judgment burden in order to prove by preponderance of the evidence that notice is
Sourcing
sufficient.
Unlimited Sourcing Unlimited is telling us what the law is. And the law is that we're going to deviate, but only if it's clear, timely, and unambiguous. That's the law as I understand Sourcing Unlimited. You're telling me I shouldn't take that as the law.
I am telling you sincerely, Your Honor, that I...
Of course it's sincere.
Yes, I am telling you that I do not think that Sourcing Unlimited stands for that proposition. Sourcing Unlimited took pains to confine itself very, very carefully to a summary judgment record in which unambiguous notice was delivered. And the question is unambiguous notice sufficient? The answer was yes, full stop. Then the question becomes, and this is really the most interesting part of the case, I think of unambiguous notice this way. It's sort of like objective manifestation of assent in contract. If you send a writing that a reasonable person must construe a certain way, you are bound, whether you form a subjective meeting of the minds in the contract case or whether you have a subjective appreciation of the intent being delivered to you.
So accepting that for purposes of argument, and I get your distinction between summary judgment and trial, that the standard is reasonable certainty, convey with reasonable certainty the information reasonably needed.
Yes, Your Honor.
Why wouldn't the manner of delivering notice be relevant to whether the notice conveys reasonable certainty? In other words, if Cummings, knowing that the contract says it's got to be registered or certified mail or the equivalent, here's IPI say, we're leaving, we intend to leave, and Cummings says, okay, if you really mean that, you've got to give notice in accordance with the contract, then why isn't it reasonable for Cummings to say, okay, if they don't give that notice in the contract, then they must not have really meant it?
Again, I don't think a subjective assessment of whether they meant it is what the case turns upon.
No, it's not. I don't mean it to be subjective. The contract says a certain manner of notice. Cummings says to IPI, remember, you got to give notice in accordance with the contract, and then IPI doesn't. Why wouldn't a reasonable person in Cummings' position understand that they didn't exercise their ability not to extend the lease?
Your Honor, we do not contend that Cummings, that you can't consider and that Cummings couldn't consider the means of delivery. We do not try to put that into the, we do not try to declare that that's irrelevant and there's no difference between email notice and a certified letter at all. So that's not our position, and I want to make sure the court understands we're not staking out so strong a position. This sort of, I feel myself toggling between Your Honors in the middle and on my left, because the two questions are related. If I could get back to the analogy about sort of objective manifestation of assent and so forth, objective delivery of a piece of information. The reason that objective statement of what is being delivered or agreed to matters so much is because the court does not try to fathom what somebody really understood in every instance when they're on the receiving end of the writing, because somebody could always try to talk their way out of that writing, and then it just becomes a pure meeting of the minds. It's one word against another word. So the purpose of the objective or the unambiguous notice is to say, well, whether you knew it or not, you're stuck. But in this case, we have something better. What's better than objective written notice is someone's testimony on the receiving end saying, I get it, I get it, I get it.
He says, and this is at the bottom of page 20 of your brief where it's quoted, Martin says he understood as of that day, or as of that time, that the intention was to leave.
Yes, Your Honor.
Can I interrupt for a moment? This was a trial. So unlike Sourcing Unlimited, which I think it's a harder burden for you, when you had a jury waive trial, and regardless of what Martin thought IPI meant, IPI was the one that had the responsibility to clearly and unequivocally give notice. And when I read the decision by the judge, correct me where I'm wrong, the judge said, you fell short. Who cares what Martin thought you might have meant? The responsibility to provide notice, whether email or otherwise, is on you. He made a factual finding. And so the judge abused his discretion in hearing the witnesses and looking at the notice and saying, that wasn't clear and unequivocal. Whether Martin, let's just say that I write a notice and I say, I'm thinking maybe I kind of sort of want to end this lease. And the other person says, yeah, I thought she was getting out of there. Who cares what Martin thinks when the first hurdle for you to get over, which when I read this decision, the judge says you didn't.
Yes, Your Honor. Your Honor, I am in disagreement respectfully with anyone on the court who says that notice has to be unequivocal. The Seaboard Casualty case says, from the First Circuit, says notice does not need to rise to the level of unambiguousness. And I continue to contend that Sourcing Unlimited decided only the case before it. I've read a lot of this court's cases, and they all inch along.
Right about that, counsel.
They inch along.
You may be right about that, except if we're making an exception to the plain language of the agreement.
Yes, Your Honor.
That's the problem you've got,
Yes, Your
okay?
Honor.
That's what Sourcing Unlimited is dealing with. And it was dealing with the language we're dealing with here.
Yes, Your Honor.
And it said, you know what? We'll let you get out of the plain language of the agreement, but it darn well ought to be unambiguous. Now, why isn't that good law?
It is good law.
Okay, well, if it's good law, then it seems to me a lot of what you're saying here today is not particularly helpful.
Your Honor, I think I have a fundamental disagreement with anybody who asserts that, because when we are trying a case by a preponderance, a lack of ambiguity is what allows the court to say, this doesn't need to go to a jury. There's no question. There's no question what they understood.
And if it's a question of what someone reasonably understood, then that's a jury question.
It's a facts and circumstances test, Your Honor. And the substance of the writings are bedded down in the context of the oral communications. And I cite good law for that, going back to Savigny versus Dowd in the SJC, I think 1965. Spine Frontiers to the same effect. Judge Laureate, I know that's not this court's decision, but Judge Laureate was very clear. The facts in these cases are very similar.
Spine Frontier is not binding on us.
Yes, Your Honor, I understand.
Cummings is very helpful.
I beg your pardon?
Cummings is pretty helpful. We wrote it, and it's on this language. You say, oh, that's a summary judgment decision, but the whole case, that whole case is about whether or not they're going to allow someone to deviate from the language of the agreement, and which is what you're trying to do here.
It is, Your Honor. But what I'm saying is this, that the court was referring to the Sourcing Unlimited versus Cummings?
Yes.
Yes. In Sourcing Unlimited versus Cummings and in Spine Frontier in this court, both times there was an allowance for notice by email because the deviation from what the contract required was deemed immaterial on the facts and circumstances. And I think my effort here is to slot right into that exact reasoning. It's not that I fight that reasoning, it's that I adopt that reasoning. But that I would like to say that when Joseph Martin repeatedly says, yes, I get it, yes, I get it, yes, I get it, and I never received any other notice that gave me any other idea. I never received any other writing from them that gave me any other idea.
No, but you're leaving out one part, which is,
Yes, sir.
yes, I get it, but IPI, remember, you need to give notice in accordance with the lease.
That was stated on February 13th, in the February 13th meeting, and I don't run from that fact. But after the February 13th meeting, they are receiving exactly the kind of email notices that do suffice to put them on actual knowledge. There's not anything we've discussed.
Testify? Did he? Is any of the testimony? I'm looking at it
Yes,
right
Your Honor.
here. So I'm looking at what you excerpted. You understood from that was their intention. Yes, and then later it's what their intention seemed to be as of that day, and then again.
As of that day.
On page 22, as of March 13th, you still understood from the writings you had received before that Innovation Pharmaceuticals did not intend to occupy the current premises. Yes. Did he ever put it in terms of something other than intend? That they had given notice that they would not, for example?
No, Your Honor. However,
So why isn't that subject? So this is the problem I had when I was reading the brief. I
Yes, Your
kept
Honor.
seeing the word intend, and I kept thinking, well, that's a statement of present intention. But we have an agreement that tells you how to tell us what you are actually going to do.
yes, Your Honor, I'm emphasizing that this talks about intent because the case law talks about intent. Spine Frontier does, and I do not recall the other decisions that I cite in my brief, but intention is what matters. And if the court reads that part of the factual section of my brief concerning the letters that Cummings uses by its own measure, its own
Well, if IPI had gone to Cummings and said, look, it's our current intent not to renew. It's our current intent. It's our intent. We don't intend to renew. If you want to negotiate the price, though, we'll have a conversation with you about that.
I think that's what always happens in these cases.
It's absolutely what happens in
Yes, Your Honor.
commercial real estate all the time.
Yes, Your Honor.
So that statement, I don't intend, that statement is not unambiguous notice, right?
I disagree, Your Honor. The case law says that delivery of notice of intent suffices. And Cummings' own sort of protocols, when they deliver intent, they deliver notice of a desire or notice of an intent. So intent is, in this case, is soaked in circumstances and law that validate the communication of an intent. Particularly, Your Honor, what you just said, a statement of current intent would be a cute way of saying maybe yes and maybe no. But that's not what my client was saying. And they didn't know about this. So, I mean, I think if the court goes against us, it has to sterilize the decision or the basis for its decision of the fact that Cummings actually knew from the first time of its admission right through the end of the period. Actual notice seems to me to be the touchstone based on Hickey, Grimm versus Venetia, and other cases. Actual notice is what counts. I'm familiar with the jurisprudence of this court.
Well, wait a second. I'm sorry, but I want to pursue that for a moment. You equate the word intent, as it's used in Martin's testimony, with actual knowledge, right? But that's not, isn't that a finding of fact? And that is not the finding that the judge made.
It's actual knowledge of the tenant's intent, Your Honor. And by the way,
Actual knowledge that they're not going to renew, which is different, I think.
It is, but I've thought about this a lot. Every statement that we are not going to renew, no matter how unequivocal, is statement of intent, because you could just squat
I
and be
agree with
subject to
that.
holdover.
No, I've thought about it a little bit too.
Yes,
Counsel.
Your Honor.
Sure, not as much as you have, but I thought about that. Okay.
So why don't you take like 30 seconds to finish up, since we've taken a lot of your time. If you have any closing remarks.
Yes, Your Honor. There's one point that we haven't touched upon, and it's well covered in my briefs, but I'd like to emphasize that it is Cummings that calls this an automatic extension and not an automatic renewal. And Massachusetts appellate law is clear on the difference between automatic extension and automatic renewal. Cummings has so far succeeded in getting a judgment for every penny of every square foot of space, because automatic renewal is everything. You're stuck with the whole thing. But necessarily in sort of the mirror image is this, that if we give notice that we are not taking back the entire space, and if we're getting rid of the lab, and we're changing it drastically, and we want to move someplace else, that's a statement that whatever lease relationship we may remain in with Cummings, it's not here. And Cummings well knew that. Thank you, Your Honors. And that suffices if we communicate that much in an automatic extension context. Thank you, Your Honors.
All right, Mr. Barker for Cummings.
Good morning, Justices. Mike Barker on behalf of Appellee Cummings Properties, LLC. May it please the Court. The trial court ruled that Innovation Pharmaceuticals, Inc. breached the parties' lease agreement by failing to pay rent in January 2020, that is, in month 16 of the extended lease term. In this appeal, Innovation asks this panel to rule that the lease terminated on September 30th, 2018. In doing so, it asks the panel to disregard pages of extensive factual findings made by the trial court.
Okay, but the judge did not deal with the testimony quoted on, I think, pages 18 and 19 of IPI's brief, where Mr. Martin says, I understood they intended to leave, in essence.
Well, I think
what do you do with that? She didn't reckon with that, and she didn't apply the standard that appears to come from some of the prior cases that IPI cites about what's required is conveying with reasonable certainty the information reasonably needed.
Yes, Your Honor. So a couple things on that. First, in order to even, ultimately what's at issue here, what the Sourcing Unlimited case focuses on is the materiality of the deviation. And here the trial court began with the substance of the email communications that Innovation points to as a belated litigation strategy in an attempt to demonstrate that there was some sort of written notice, even though the senders of those emails were not even aware of the written.
But if Mr. Martin understood that it was IPI's intention to leave the space, why isn't that the knowledge that they're opting not to extend the lease?
That was
not to renew the lease, excuse me.
So that's a contested issue of fact, and at footnote 26 of our brief, we actually address all of the snippets that Innovation points to, and you'll note that almost every single one of Mr. Martin's pieces of testimony on this issue anchor his understanding to a snapshot in time. As Your Honor's pointed out, every time he says that seemed to be their intent as of that day, as of that time, because everything that Mr. Martin understood was within the factual context of the February 13th meeting.
But he never received anything expressing a different intent, did he?
He did, Your Honor, because in multiple communications from both of the representatives of Innovation that communicated with him during the end of the notice window, both Jane Harness and Nancy Chaludian on behalf of Innovation, in each of their emails, first Ms. Harness on February 20th says, we want to put on the back burner looking at additional spaces because we have plenty of time to figure this out. Later on March 2nd, Ms. Chaludian emails Mr. Martin that it's too soon for IPI to commit to a decision. That is the last.
She doesn't say to commit to a decision. She says too soon to commit to a particular different space.
That's right, Your Honor.
Because they're still deciding how much they're going to need 6 months in the future. That's not the same as saying it's too soon to commit to leaving.
That's true, but that communication must be understood in the factual context in which it was given, which is Mr. Martin and Mr. Drahosky, after the February 13th meeting, understood that Innovation knew how to provide written notice in accordance with Section 21 of the lease, if it so wished to. So he's not interpreting any of those.
Why do you say that? The judge found that they hadn't even looked at the lease. Why do you say that they knew how to give notice pursuant to that provision in the lease?
Justice Englander, I was referring to Mr. Martin and Mr. Johosky on behalf of Cummings, understanding after having clearly and explicitly pointed innovation to Section 21 during the February 13th meeting. It's the judge.
Did the judge find that? But, the judge found that they said that. Did the judge find that innovation understood?
Yeah, that Cummings.
I don't think she did, because I think she said the people who made the decision hadn't read the lease.
Maybe we're talking past each other. The judge specifically found in 2 instances in the decision that Cummings understood that innovation knew how to provide written notice twice. And that's what the facts turn on here. So, and that bears on your initial question.
Do you know where she made that finding? That's interesting.
I do, Your Honor.
I think it's Record Appendix 1300, page 16 of her decision.
Page 16 of her decision?
It's also in our brief, and I will find you that pin site.
Well, that doesn't say that Cummings understood that they knew how to do it. It simply says that, and finds that they were told by Cummings how to do it.
No, it does say that they expected.
Next page. I see on page 301, page 17 of her decision, in light of the communications at the February 13th meeting, Johosky and Martin expected that if IPI decided to opt out of the automatic extension, IPI knew how to exercise that option by serving written notice in accordance with Section 21.
And that's a critical finding, Your Honor, because it informs the rest of the interpretation of all those email communications, none of which, I should note, on their face were sufficiently clear as a matter of law to even find that they could constitute written notice. Our argument is really threefold. In the first instance, there's ample law to support the notion that even if Your Honors were to disregard Sourcing Unlimited, as counsel suggests, these emails still do not rise to the level of reasonable certainty in communicating the essential fact necessary under either the Commissioner of Corporations and Taxation case, which is the seminal case which led to the Kerry case.
But what if there was knowledge and fact? You know, what if there's knowledge and fact on the part of Cummings, which is what your brother argues that, right? He says, look, the testimony of Martin shows knowledge and fact, and it appears there's not a finding by the judge addressing that.
There is not a finding.
That Martin testimony.
There's not a finding specifically on point as to Martin's actual knowledge. There's just what he expected coming out of the February 13th meeting. However, there's ample support in the record which demonstrates that this whole issue of what Martin knew and when is contested. In our brief, we quote...
Can I just interrupt for a moment? You had 3 points. One is, as a matter of law, that IPI didn't do enough to communicate its intention to continue with the lease.
Correct.
So in that instance, it doesn't matter what Martin thought or knew or whatever. It's just, it didn't rise to the level.
That's correct, Your Honor. Whether it's an unequivocal standard under Sourcing Unlimited or reasonable certainty of the essential facts under the standard that my brother proposes, it doesn't rise to that level. You can look at the Commission of Corporations case we cite, the Kerry case, which says a notice which gives no indication that it's intended to be notice is insufficient. You can look at the Jasty case, which is a termination right out of the First Circuit, where you don't use language referring to the contractual action being undertaken, whether it's I'm moving out, I'm not renewing, I'm invoking the termination of section, the automatic extension.
To respectfully disagree with matter of law. Number 2 is, even if we consider Martin's testimony, it's only of a current intent.
That's correct, Your Honor.
That's an ever-changing kind of position. What they feel like today may not be tomorrow, and it's clear and unequivocal that he told them, this is how you do it, and they didn't.
That's right. And
I missed the third. Then what's the third? If we don't like number 1 and we don't like number 2, what's your third argument that you still get an affirmance?
Yeah, well, right. Number 2 being actual notice, am I correct? Is that what So we dispute that there was actual notice, and we have a block text in our brief which has Mr. Martin's testimony where he clearly says, I asked him, how did you expect to receive written notice? And he says, written notice in accordance with the lease. Did you interpret any of the emails during the opt-out period as serving the purpose of communicating a decision about the automatic extension? He says, no. There's, in our brief, I don't have the footnote on.
Yeah, I recall reading that.
My third point.
You crossed him on the depot, I assume. That's how that evidence got created?
I crossed him. He was
Or
direct
trial.
examination at trial, Your Honor.
Trial, okay.
I was correct. The third point is that, which it seems that the panel is sensitive to, is that the gravamen of the analysis in the Sourcing Unlimited case and all of the prior cases where a party fails to provide notice in accordance with the agreement is that it can't materially deviate from what the parties agreed to. Here, you have a notice provision that is exceptionally clear. It requires service of written notice at a particular place at Cummings headquarters, addressed to Cummings, not to an account manager up in Beverly at a different location, not by email, because the notice provision is explicit. No oral, facsimile, or electronic communications shall have any force or effect. And as I think Your Honors appreciate, Sourcing Unlimited stands for the proposition that where you have a party who contravenes the express language of the agreement, that notice better be perfect in every other regard. It cannot have led to a dispute as to the fact of notice itself. That's Gerson Realty. That's a tenant.
Mr. Drahowski testifies that the tenant doesn't have to use magic words to exercise this option. The tenant just has to explain what it's intending to do. That's from Record Appendix 1, page 728, his testimony. Why? And so Drahowski says tenant has to explain what it's intending to do. Martin says, I understood they intended to leave. Why doesn't that get IPI where they need to be?
A, because that's not what the parties agreed to. B, because it wasn't interpreted. Mr. Drahowski and Mr. Martin are very clear.
What the parties agreed to, we know from Sourcing Unlimited, is not necessarily dispositive as to whether notice is adequate.
Provided that the party purporting to have given notice carries its burden. The Patriot Power case cited by the trial court, which, by the way, the trial judge in this case happens to be the same trial judge who authored the underlying summary judgment decision against Cummings and Sourcing Unlimited. So she's well versed in this area of law and these facts. But in any event, the trial court pointed to the fact and began her analysis by establishing that after 6 days and 7 witnesses and 173 exhibits, Innovation failed its burden of proof under Patriot Power in demonstrating that it provided notice.
Okay, so what is the burden?
That burden of proof is to demonstrate that it's where a contractual obligation, the termination of a contractual obligation is at issue, the party purporting to have terminated that right must have met the condition by its affirmative act. And I contend, as a matter of law, Innovation couldn't have established that because the authors of those emails weren't even aware of the contractual obligation to begin with. And in any event,
Sourcing Unlimited seems to say in footnotes 9 and 10 that an expression of intent is sufficient. We reject Cummings' claim that JumpSource could have changed its mind after sending the email messages expressing its intent to invoke the option.
Well, respectfully, I contend that this entire litigation stands for the opposite point to prove that wrong, which is here, you have a party that acted as though it was business as usual under a lease for 15 months. In fact, in their own first filed SEC...
Don't jump ahead to that, because that doesn't... I'm not persuaded by that myself, because you wrote them a letter that said, you guys didn't, before September 30th, you wrote them a letter that said, hey, you guys didn't do this correctly. You guys are stuck. You're stuck here for the next 5 years. That's what you wrote them, April 23rd, right? So their subsequent conduct is influenced by your decision. If you were in breach when you wrote that letter on April 23rd, I don't know that their subsequent conduct is anything that you can rely on. Let's stick to the question of what was said before March 30th. That's, I think, where you got to win the case. You follow me?
Yes, I understand, Your Honor. I didn't follow what the instant question posed is.
No, you start jumping ahead and telling us what happened for 15
You're
months.
getting to waiver,
Not
and
helpful.
you're getting to waiver, and we're suggesting to back up.
No, I mean, my suggestion was
why-
merely that the party's conduct is the best
So
expression.
Mr. Drahosky says is expression of tenant's intent. Tenant has to explain what it's intending to do. Certainly, our decision in Sourcing Unlimited suggests that expression of intent is sufficient. Mr. Martin understood that IPI had the intent to leave. Why isn't that enough?
He didn't understand those communications as having the purpose of communicating a final decision as to what innovation was doing, particularly
But
because
does the judge, he testified that he didn't have that understanding. Does the judge have to evaluate whether that was a reasonable understanding?
I don't think so, Your Honor, given the burden of proof. I mean, it's the burden, it's the innovation's burden of proving that Mr. Martin had that understanding. It's not our burden of demonstrating that he didn't have
he
that.
he understood their intention. The question is, when he says, but I didn't think it was their final notice, does that have to be a reasonable belief? I mean, if they deliver him a certified letter that says we're not extending or we're not renewing the lease, and he says, oh, well, I didn't really understand that as a final decision, that's totally unreasonable in light of the language of the lease, right?
Sure,
So
Your Honor.
you can't just negate what they do by saying, I don't believe it. His belief has to be reasonable. Did the judge evaluate whether his belief here was reasonable?
No, the judge did not reach the issue of the reasonableness of Mr. Martin's interpretation of the emails because she found in the first instance that they were unclear. You know, having made her extensive 36 pages of factual findings, she analyzed all of this in context. Mr. Martin had continuously, for months before the notice window opened and for months into the notice window, been asking specifically.
Right. You know, what's really interesting to me about that, and maybe the judge did address this, but this, this is the third case I'm aware of this particular client causing this particular kind of problem coming to the appellate courts. Why didn't Cummings say on about March 29th, hey, you guys gonna come back or not? Why didn't they do that? Because Martin, you're right, he was like way out in front. Hey, I'd like to know what you're going to do. I'd like to know what you're going to do. I'd like to know what you're going to do. And then as it got close to the date on which they're dead, nothing. Why didn't that happen?
Because these are two sophisticated commercial entities that we're dealing with in the trial court.
And they want a gotcha.
That's, the trial court made a
I know the trial court found specifically it's not a gotcha. I'm asking the question. I understand that it's not in the record, counsel.
Why did Cummings not? Well, because it wasn't a bargain for term where you have two sophisticated entities that negotiate extensively. It was not an obligation, just as the trial court found. And if there are no further questions, I would submit on our brief.
All right. Thank you. Thank you both. Well argued on both sides. All right, our next case is 24P 1100, Jeffrey Hagopian versus Jeffrey Wilkinson. Mr. Hausler.
May it please the Court. Douglas Hausler representing the appellant, Jeffrey Hagopian. Getting to the immediate issues, Your Honor. The trial court failed to give all reasonable inferences under the 12b6 standard in favor of Mr. Hagopian as the non-moving party whose allegations were supposed to be in all reasonable inferences in its favor. And that created the issue of whether or not the facts that were asserted in the release as arising from or relating to, if the defamation claim was part of, essentially, or was included within the scope of the release. There's an alternative reasonable explanation for excluding the Hagopian's position that the defamation claim was not included in the release.
Do we first have to determine whether or not that language in the release was clear and unambiguous?
You do, but when that has to be determined, the reasonable inference of that issue, it really gets down to relating to or arising from or relating to. That language is supposed to be tilted in favor of my client in that instance.
I understand your position procedurally in the standard of review, but when we look at the language of the release, I didn't see, and please identify for me because I just couldn't find, what you were claiming was the ambiguity in the language.
Yes, Your Honor. Let me address that.
Thank you.
It's not relating to or arising from. Here's why. The federal court case focused specifically on the conduct or misconduct of state officials, a president of university, the chief of police primarily, and the chair. Not so much about their failures to give due process, give a hearing even, or to respond to issues as to why this no trespass order ever issued. That was the entire focus of the federal court claims.
But the release doesn't talk about the claims.
Well, it does because it says arising out from or relating to the complaint.
No, it says arising out of
Or
or relating in any way to Hagopian's allegations set forth in the federal action. Allegations, meaning factual allegations, and he clearly alleged the defamatory conduct that he's trying to pursue here.
No, he didn't. The word defamatory is not even used within the four corners of the federal court complaint, Your Honor.
Okay, but did he not talk about the interactions with Mr. Wilkinson?
He did. He spoke only about for historical context of the situation.
But he spoke about them. They were part of the allegations. Did the allegations here relate in any way to the allegations of the federal complaint?
I don't believe they do, Your Honor. Here is a defamation claim about whether the words that were uttered by Mr. Wilkinson were true or not true. He was not acting at that when he uttered those words. He was doing so individually. He was not doing it so as a trustee. He was not participating in a decision as a trustee to issue the order of no trespass. He wasn't conferred as the president.
Why do we have to accept that?
Because
It's not alleged in the complaint that he wasn't acting as in fact, I think it's alleged in the complaint that he held a position with MMA. That's the allegation in the complaint. Why do we have to accept he was acting as an individual?
Because it was admitted that he was acting individually. There's no dispute that he was acting, the Commonwealth argues that position. He was acting individually. He was never acting as a trustee.
It's not alleged. He may have said that in some, did he say that in a pleading? Is that it? Wilkinson said that in a pleading, I was acting in my individual capacity?
No, because he wasn't acting, it didn't make sense to assert that he was acting individually or as a trustee. It didn't say either one. All it said was there was an event, a public book signing that was at the university. And all it said is they approached each other, they had this conversation. Now, that was just to give context to what eventually happened. And what eventually happened was a deprivation of my client's civil rights. So he brought a federal claim. When he brought the federal claim, it focused exclusively on the actors that participated in the deprivation of his civil rights. The university's police chief.
So in paragraph 19 of the federal complaint, in a letter dated September 13th, 2021, Wilkinson sent a letter to McDonald and Waters containing several false allegations against Hagopian.
He
Doesn't
did.
use the word defamation,
No.
says false allegations. Okay? And I think that's in there because it was the predicate to the acts that are complained of as violating his civil rights. The predicate to that was hearing from Wilkinson, right?
We presume so, but that was never fully explored, Your Honor, respectfully. It was what was
Okay, but
I'm sorry.
But that's there. Paragraph 19 is there in the federal
speaks for
complaint.
itself,
So
yes,
then
Your
we
Honor.
go to the release, and we're looking at arising out of or relating to in any way the allegations in the federal complaint. Those claims are released.
I don't believe that would,
So
sorry.
this new claim doesn't arise out of the allegations that are there in paragraph 19?
Your Honor, I think the words arising out of or relating to are with respect to the claims that have been asserted in the federal case, the deprivation of due process.
That's not what the release says.
The release says arising out of or relating to.
Sure it does. Arising out of relating to the allegations, not the claims.
I think that's too broad a scope.
Legal claims versus factual allegations.
I believe that if that's the intended scope of release language at this point, then every release that's going to be drafted is never going to use the word allegations in it. The intention was to release claims that had to do with respect to the due process claims and that alone. That's all.
When you look at the defamation claim that was
Yes.
filed compared to the federal lawsuit, it appears that the defamation claim is based upon the allegation that your client was told, hey, if you keep pushing things, things are gonna not end well for you,
I
correct?
think that's a quote, yes.
That's paragraph 18
Yes, Your
of
Honor.
your factual allegations in the federal complaint.
Yes, Your Honor.
So in order for this court to agree with you that somehow that release doesn't cover that, we'd first have to find that the words relating to, arising from, are ambiguous
As a matter of law, yes.
as a matter of law. How do we get there? How is that ambiguous? It seems like you look at the allegations, and if they're arising from or relating to it, where's the ambiguity?
The ambiguity is in how it's construed by the parties themselves, or what's reasonable construction of those words, and that inference that favors Hagopian. So, for example, if Mr. Wilkinson said participated in a board meeting and said these kinds of words, I think the release language in the release would apply because it was arising from or relating to an action that led where he was taking action as a trustee, participating in a board meeting. But that's not what happened, and that's not what the allegation said. The allegation said an individual, it could have been Wilkinson or some other board member, could have approached him and said all these terrible things to him, reiterated that, published it, but the only things that were being examined in the federal court were what were the actual actions or omissions that took place that led to the ultimate release here. And the release was limited to the due process rights, because that's what the Commonwealth admits it was paying, $14,500, which was basically reimbursement
You can
of
get a
the legal-
release for more than what is claimed. I mean, that happens all the time.
The dollar
Right.
amount, absolutely, Your Honor.
No, but I mean, I practice civil law. I would always seek a broad release, right? Because I don't know what else is going to come back. But the one thing I want to do is be done with it. My client wants to be done with it. And when you say to me that Wilkinson was not acting in his official capacity, the allegations in this complaint indicate that he had official capacity. It's like paragraph 6. It says he's a trustee, he's a this, he's a that. So if I'm representing these folks, what I want to do is make sure there are going to be no lawsuits arising out of what happened. Why can't they do that? And why isn't that exactly what they did? They added the word trustee. Trustee was signed by your client, right?
Yes, Your Honor.
I'm just struggling with, you want to make this a case that needs to be litigated over the meaning and intent of the release, right? That's how you want to get by the motion to dismiss.
That's correct, Your Honor.
Okay. And the words arising out of or relating to, I think those words are in almost every release I ever drafted.
I agree
So
with
I'm going to have a hard time thinking those are ambiguous.
The words
So-
themselves, yes, I agree with you.
In any way, that doesn't sound ambiguous. That sounds like as broadly as I can write it.
Except if you're limiting it to, the Commonwealth is limiting it to the actors for whom it is representing in that case. It certainly was not representing Mr. Wilkinson individually in the case.
Well, the release says releasing trustees individually and in their official capacities.
That's with respect to the people who were the actors that were involved in the questionable conduct in the federal suit. We're not questioning Mr. Wilkinson's actions in the federal suit.
It says any of the Commonwealth's current or former employees, officials, agents, officers, trustees, attorneys, successors, etc., individually and in their official capacities. Any of them, not just the ones who were defendants in the federal suit.
It would mean that the board, as a board member, as a trustee, yes, he was, but he's not being sued in the Superior Court as a trustee. He's being sued in an individual capacity. It's his words. His words were not binding on the university. He's a totally independent, intentional tortfeasor, not even being considered because it's a state law claim and had nothing to do with the federal rights claim. The federal rights claim had to do solely with respect to the complete, utter lack of process that was given to Mr. Hagopian, who was threatened with, being arrested just for being on campus. And that is a decision that was not made by Mr. Wilkinson. It's a decision made by the president and the chief of police, and that was the basis for the federal suit that settled. And it was challenging that conduct and that conduct alone. It never went to, nor was it intended to address, whether or not the words that Mr. Wilkinson uttered at that night were true or untrue, were they defamatory, and did they cause harm or damage to Mr. Hagopian. That never came up. And hence, it's not arising from or relating to, notwithstanding the broad language that I would agree is put into almost every release known in civil practice. But in the context of what are the actual claims that are being considered to be within that, which is the arising from or relating to. And all I'm saying is there's a reasonable alternative explanation for why defamation would, as an intentional tort, would not be included in that release. Because the Commonwealth isn't bargaining on behalf of an individual. It's bargaining on behalf of employees, trustees, presidents, officers, directors of the university.
The Commonwealth has an indemnity obligation. Is that possible?
Not for an intentional tort.
Yeah, for intentional torts, as long as they're not committed or acting in a grossly negligent, willful, or malicious manner. Chapter 258, Section 9 allows indemnification for intentional torts as long as they weren't committed with gross negligence or willfully or maliciously.
Your Honor, I have to
and
consider that one, Your Honor. I don't have an answer for that, Your Honor.
Even if we take your point, and Judge Sachs is extremely knowledgeable about this stuff, but even if we take your point, they don't, the lawsuit could get brought and the indemnity claim could be made and the costs to the Commonwealth would then be incurred in having to hire a lawyer or provide a lawyer for Wilkinson. And they may not think that he engaged in an intentional tort. They still would like to avoid the costs of the second lawsuit. And so they write the release broadly. Why is that an unreasonable way for the Commonwealth to act?
Because if they intended to include a defamation claim based on his individual tort actions, they
intended to include any suit against Wilkinson for what he did, because he was a trustee of the MMA.
But his actions, the words that he uttered were not as a trustee. The words that he uttered were individually uttered on his own behalf, not as a position of the university whatsoever.
Okay. I think we've got your argument.
Thank you, Your Honor.
Thank you very much. AAG Kramer.
Good morning. Ginny Kramer, Assistant Attorney General, on behalf of Jeffrey Wilkinson. The settlement agreement Mr. Hagopian signed, which was negotiated by his counsel, could scarcely be clearer as to the causes of action he agreed to release. Quote, all claims of every kind, nature, and description whatsoever, whether or not previously asserted in any forum. The release could scarcely be clearer as to the identity of the potential defendants it sought to protect against all future claims. Quote, the Commonwealth and any of its current or former officials, specifically including trustees, the capacity in which, as this court has noted, the defendant, Mr. Wilkinson, serves. Notwithstanding the argument you just heard, the release was also completely clear and explicit that it was intended to serve as a bar to all future litigation against the Commonwealth, its officials, in both their individual and official capacities.
No, it wasn't. It's a specific release. It's specific to the allegations in the federal complaint. It's not a bar against anybody. It's only with respect to those things that are in the federal complaint.
Correct.
Okay.
Correct.
All right.
Totally agree with that. But with respect to the allegations in the federal complaint, it attempts to, and it was intended to bar all future litigation against the Commonwealth and its officials in both their individual and official capacities with regard to the allegations.
So let's go back to the federal complaint, paragraph 19, which I read to your brother. In a letter dated September 13th, 2021, Wilkinson sent a letter to McDonald and Waters containing several false accusations against Hagopian. Is that the basis for the defamation claim in state court?
I believe so, Your Honor.
Because the allegation is different. The allegation in the state court complaint is not about a letter that was written to McDonald and Waters. It's about a phone call that was made that very day. Right?
Yes, Your Honor, but I would.
Okay, so now we've got the question arising from or relating to the allegations in the federal complaint. They're not the same. Those are two different defamatory statements. I don't know the answer to the first question I asked, which is whether or not what's in paragraph 19 is a basis for the claim in the state court, but it's not alleged. What is alleged is a different defamatory statement.
Okay.
So help me with this.
Okay, so, taking that question, I would respond by saying that how those two things are not related to one another, I wouldn't be able to fathom. I mean, it's the same incident you're talking about. It's the same statement between the two individuals. It's the same course of conduct. It's the same interaction. It's the same.
Well, it's not the same interaction. So, I mean, a defamation claim, if you're defending one of those, which you may have done, you say, well, I want to know what the statement is. Tell me exactly what the statement is, what they said, and whether it's defamatory and why. And here we're talking about, it looks like, two different statements. Now you say, I can't fathom how they're not related. And I understand that point. And that's how we should decide it?
Well, I mean, the release also states, Your Honor, that, that they arise out of or relate to in any way to Mr. Hagopian's allegations in his federal complaint, explicitly to include but not be limited to any claims, whether they're under the Massachusetts Tort Claims Act or the common law. So, I mean, I don't think that your releases, which are favored, the enforcement of which are favored by Massachusetts law, are required to set forth every single potential cause of action that could ever be encompassed by litigation arising out of or related to in any way. I mean, clearly that language was drafted by the Commonwealth's attorneys in the federal litigation in the most broad terms possible to, as you noted previously to be done with it, the Commonwealth handed over, taxpayer funds in settlement of the federal litigation, and also gave Mr. Hagopian the injunctive relief that he sought. Contrary to what is argued in the appellant's brief in this case, the federal lawsuit did not only seek injunctive relief or equitable relief and reimbursement for legal costs. It specifically in, I think, 4 out of 5 counts sought money damages. So, I mean, there's a lot of thinly sliced bologna in terms of kind of chopping up the different ways that the court below found. There's a new argument that's put before this court that was not made.
I don't know if it's that thin a slice. I mean, in its simplest form, the argument being made is we sued 3 people for violation of constitutional rights. We didn't sue Wilkinson, and we didn't bring a common law defamation claim. We settled that case against the 3 people we sued. There was no conversation about the possibility of a claim against Wilkinson or the common law, and we ought to have further proceedings beyond a motion to dismiss as to what the meaning of that release is under those sort of circumstances in gross. That's the argument, right? Is that really thinly slicing things?
I believe so, Your Honor. I mean, I note that the federal complaint was against the Massachusetts Maritime Academy and the individual defendants. And, the Commonwealth, in agreeing to the settlement of the claim, used the broadest language possible that its attorneys could come up with in terms of the claims it covered, in terms of the Commonwealth and any of its current or former officials, specifically including the ones who were sued and other ones. And in terms of the scope of it, as serving as a bar to all future litigation arising out of or relating in any way to the allegations set forth in his federal complaint, as you noted, not the claims, the allegations. So,
how do you distinguish CRAM, which seems to say, you know what, town, you're pushing this release too far?
Well, the way I distinguish CRAM, Your Honor, is that the town was completely unrelated to the driver of the car. The driver of the car, who was the defendant in the first case, was just happened to be driving on a bridge that was owned by the town at the time the accident occurred and the plaintiff's decedent was killed. The town was not involved in the first litigation. It was not named in the first litigation. It was not a party to the release. It was unknown. It was an unknown entity with regard to that first litigation. Here, clearly, this was a lawsuit against the first federal case was a lawsuit against the Commonwealth and its officials, Mass Maritime, including the chair of the Board of Trustees. So it's not an unrelated entity. I don't think that CRAM is inconsistent in any way with Judge Donatelli's decision dismissing this case.
All right, seeing no further questions, unless you have anything else to address?
No, Your Honor. Thank you. I will rely on my briefs. Thank you.
Thank you. Thank you both. All right. Next case on the list is 24P690, John Doe number 524174 versus Sex Offender Registry Board. Just want to remind the parties that this is an impounded case, as I'm sure you're well aware, so no names. And I should say to everyone else assembled, we will expect to be taking a break. We intend to take a break after the after this argument, so about a 15-minute break. Whenever you're ready.
May it please the court, Elizabeth Caddick for John Doe. There were two prejudicial errors that occurred in this case that affected the outcome of the decision. These errors were violations of the SORB statute, the SORB regulations, and the SJC decisions that discuss the due process right to an individualized hearing. The first issue has to do with the fact that Doe submitted updated, empirically validated research that shows that SORB's Factor 1, that lumps all people suffering from pedophilia as having one high-risk factor, is incorrect and outdated. The research, most of it published after SORB updated its regs in 2016, shows that when researchers separate those suffering from pedophilia into exclusive pedophiles that are only attracted to children and non-exclusive that are attracted to children, adolescents, and adults, the reoffense rate is 2 to 3 times higher among exclusive pedophiles, and that the reoffense risk of non-exclusive pedophiles is the same as anyone who committed a sex offense.
So may I ask, if your expert had not testified about these articles or had not referred to them in his report, as he did briefly, would the hearing examiner still have an obligation to consider them?
Yes. According to the 2 SJC cases dealing with this particular issue, the case that dealt with a hearing examiner that was presented with updated research on age and how advanced age significantly, dramatically lowers the risk to reoffense. The hearing examiner ignored it. The SJC found that it was arbitrary and capricious and vacated it. The same happened a few years later when there was a hearing in which the Doe, a female, presented articles about the low risk to reoffend of females. I do believe in that case that the attorney also had an expert testify, but the court did not clarify or hold relevant the fact that there was an expert on the age case or the female case.
Can I interrupt for a moment? It seems as if you're challenging in general, not just this hearing examiner, because the hearing examiner did listen, maybe didn't agree fully with Dr., is it D. Cataldo?
Yes.
Right? But the basis of your argument seems to be even greater and broader, that SORB category of high risk for pedophilia needs to break out non-exclusive and exclusive and not lump everyone into the high risk category. And so my question is this the right vehicle?
Yes, because I understand you're talking about a declaratory judgment, but in this case, when you look at how the court and the parties handled the advanced age and the female case, they did not have to challenge the regulations. All they had to do was use Factor 37 and Factor 35. Both of them say, well, Factor 35 has a shall. The SORB shall consider empirically validated research. And so all you have to do is use the regs and the statute that's already in place that gives SORB the obligation to look at new research, because it would be really if you're looking at a due process right to an individualized hearing, submitting new research that is changing all the time when it comes to sex offense, recidivism, and dangerousness, having to challenge a regulation that just isn't updated is not only much harder, but it also doesn't give the individual offender an individualized hearing at that time. And so the regulations give the offender under Factor 37 the ability to submit additional information, the fact.
So what do you think should have happened here?
The judge, I mean, the hearing examiner should have acknowledged, and not just ignore, should have acknowledged this robust research that shows the.
And therefore?
Should have found that high-risk factor one did not apply. It did not because it only.
Because the research shows that if you are non-exclusive, your risk of reoffense is no different than anyone else
Who committed
who is
sex
a sex offender,
Right.
and therefore
Then the other
factor one does not apply.
Exactly. And the other factors will apply, that he abused a 4-year-old girl, there was a difference in age.
Would have required the judge to ignore or to hold that despite what factor one says, I'm not going to follow it. I'm not going to consider factor one as applying here.
Right,
As
right.
applied challenge.
Right, exactly. That
And let me ask another question. So in this case, there is a finding by one of the, at least one, of the folks who examined your client, that he prefers children. That's his primary. Does the research address that issue at all?
No, it does not. It does not say that if on this.
If the hearing examiner had considered the materials and concluded that they really didn't apply to your client because of that finding, we'd have a hard time overturning that.
Well, you would, because what would be his basis? The hearing examiner must have a.
Would be that apparently the materials you're relying on don't address somebody who says my primary interest is in children.
Well, then what basis is the hearing examiner going to make that decision? He has to base it on empirically validated reasons, and there is no empirically validated reason.
No, he can base it on factor one. It's your job, as Judge Sachs just indicated, it's your job to indicate that the factor doesn't apply.
It doesn't, and I went through all of the research cited in Factor 1, and none of them address exclusive and non-exclusive. None of them address, a bell curve of interest in whether it's a preference for children or adults on a scale of someone who is attracted to both of them. I did cite research that showed that over a period of time, those who are exclusive pedophiles do not change their interest and become attracted to adult females. But those who are non-exclusive, over time, change their preference to adult females, and it's not because they're suppressing their.
The hearing examiner, I want to make sure I understand a couple things. The hearing examiner can't be obligated to accept whatever research you put in front of him as being accurate.
He is. As long as it's empirically validated, according to Factor 35, he shall consider empirically validated.
But he doesn't have to, he shall consider.
Right.
Doesn't mean he has to accept it. We have experts who come into court all the time that we don't accept.
Right. He has to, okay, he has to address it.
Deal with it.
He has to address it.
Either say, this doesn't apply to Mr. Doe, or I don't find this research applicable here because I think, notwithstanding his statements, it looks like Mr. Doe, and I find as fact his primary, nearly exclusive focus remains children, or something like that.
Right, but.
Got to address it.
But remember, it's the board that has the burden of proving by clear and convincing evidence his current risk to reoffend. And so SORB cannot say, I reject relevant research, and so I find just the opposite. They have to have a reason for it. And if the regulation doesn't support it, and it doesn't, and the research cited in it doesn't, then that cannot be a basis for finding a high-risk factor based on his diagnosis of pedophilia.
See, one of the things that's bothering me about this is age and gender, which are the two examples that you rely on, are very gross distinctions, right? And easily understood. In your argument, you've moved from that kind of, that kind of line drawing to something that is, a line drawn within a particular type of mental abnormality applicable to factor one. And I'm wondering whether the same analysis applies or whether it doesn't, I guess.
If the concern is on the accuracy of whether someone is exclusive or non-exclusive, in the research cited, they use the PPG, which actually shows whether you're attracted to females or children, females and children. And in that research, it was able to demonstrate that there were those, generally like 13%, it seems to be a sort of standard non-exclusive pedophiles are about 13% of all those suffering from pedophilia. They didn't change when they were shown sexual photos of adolescent girls or adult females, but those who were non-exclusive did. And it showed over a period of time, these are people who got sex offender treatment, they changed dramatically to a greater.
No, I understand
Okay.
your argument. Your argument is that it's not fair to lump all pedophiles into the same basket, and factor one doesn't consider updated research. But your challenge is as applied, and it seems as if your client's a pedophile. Whether he's non-exclusive or exclusive, he's a pedophile. And even your expert says, okay, even non-exclusive pedophiles are a risk. And the hearing examiner doesn't, when we talk about as applied, doesn't have to accept A, the expert testimony, but B, accept the evidence as you describe it. So in other words, the information about whether he was attracted to children, whether or not he believes certain types of relationships are appropriate or not, and that whether factor one applies. I mean, as applied, I'm having a difficult time. I understand generally your claim that, because then you'd have 10 different hearing examiners saying, well, I think factor one should consider the difference, and I'm not going to discount that, or I am going to discount that. That's not what we want. We want these factors, if they're going to be challenged because they're not up to date, for everyone to say, hey, we learned new things now. You can only consider non-exclusive or exclusive pedophilia when you apply factor one because the research is now updated. Not just like, hey, in this case, he says, I like young kids and sometimes I like adults. I just don't see as applied how you get there.
I think by focusing on factor one and whether it's an as-applied challenge or not, I was never challenging factor one. I was just saying it didn't apply to him because he's non-exclusive and cited to all the other factors and the SJC case law and the statute that said that he's entitled as the constitutional right to an individualized hearing. And by ignoring these articles, by ignoring the research, by ignoring the testimony of his expert, he was denied his constitutional right to an individualized hearing. And that is the greater argument, and there's a great amount of statute, regulations, and SJC law that supports the fact that the hearing examiner must use this evidence in order to give him his correct individualized hearing.
Just want to caution you, you've got about 30 seconds. Do you want to address any of the other issues in your brief?
Yeah, in the rejecting the expert's opinion, the hearing examiner gave a disingenuous reason that is in fact against the law, the case law, when he said, well, he didn't look at his empirically validated testing, which factor 35 says the hearing examiner shall consider that he was ignoring it, or gave it minimal weight because he didn't address the SORB factors, when first he can't do that. The SJC case law says you can't reject an expert's report because he didn't consider all the SORB factors. And the SORB factors are included, maybe have a different factor number, in the empirically validated tool the expert did use. Thank you.
Right. Thank you. Attorney Greenaway.
Thank you. Good morning, Your Honors. May it please the Court, Attorney Roxanne Greenaway for the Board.
May I start with a question about what I understand are some new board regulations?
Sure.
Do those change the classification factors in 1.33? And if so, do they change them in a way that's relevant to this case?
I don't think that it has changed. It has, in Factor 1, it doesn't include the language that says over 16, that it would apply to people who are over 16. That is not in the new factors, but that is not.
Okay.
It doesn't change our.
All right, that broadens the
Evaluation
scope of Factor 1 in essence. Is there anything the board has published that explains the difference between the old regs and the new regs? Because we have a lot of cases here, as you can imagine.
They just came out, so nothing yet. We don't have anything yet.
If the board has something
April
authoritative,
25th.
if the board has something authoritative, it would be helpful to submit.
Okay, thank you, Your Honor.
Are the new regs supposed to apply retroactively in any way to cases that have been previously heard?
I would indicate that they are current as of date. I don't see anything that indicates retroactivity, but I don't, again, the way they're written, I don't think with this particular case, with the factors that are involved here, it's going to make much of a difference.
Okay, all right. So why didn't the hearing examiner address the articles saying that under Factor 1, mental abnormality, that pedophilia is just too broad a category? We need to distinguish between exclusive and non-exclusive pedophiles.
Well, first I would point out something that Justice Englander pointed out earlier with regards to the other cases that are published with age and female. And I want to distinguish that when those research came into those cases, there were no factors on those two particular categories. Here, we have a category on pedophilia. So that really is a big difference.
Why is that? I mean, you had factors that applied to everyone, and the claim was that you can't lump everyone together. Age makes a difference. So then you created a factor. You had factors that applied regardless of sex, to males and females. And the claim was that sweeps too broadly. You've got to differentiate. Here, you've got a mental abnormality factor that doesn't distinguish between exclusive and non-exclusive pedophiles.
And I don't think there's anything in the DSM-5 that indicates that someone who is diagnosed with non-exclusive pedophilia is not a pedophile. So that's what...
No one's claiming that. I mean, the term appears in both. The question
Right.
is, doesn't the hearing examiner at least have to reckon with the point of those articles? Either say there's no scientific consensus, or I don't find these persuasive, or I believe Mr. Doe is really 99% focused on children, so he's not really a non-exclusive pedophile. Doesn't the hearing examiner have to confront those, even if he doesn't have to believe them?
I agree, Your Honor, and what I would say, I would prefer if they were to write it out more clearly. However, when you look at the hearing examiner's decision, that there are parts of the decision that addresses that. The hearing examiner is clear that the evidence that's in the record indicates that he continues in 2022, when the hearing is in 2022, and he's evaluated by his expert in 2022, and they're still indicating that he has this interest in children from ages 4 to 5, and that is as current as you get.
Okay, but how does that answer the articles that say someone who is interested in both children and adults is at no higher risk to reoffend than any other sex offender?
And if I may, I would indicate that, again, in the hearing examiner's decision, you will see he continues to indicate that there is no relationship. This individual has never had a relationship with an adult female. So there is nothing in the record that shows any exhibition.
So the hearing examiner doesn't believe that Mr. Doe is a non-exclusive pedophile?
I wouldn't say that he doesn't believe. I would just say that obviously there are two diagnoses that says that, right? And the hearing examiner acknowledges that. So I wouldn't say that he doesn't believe it. What I would indicate is in addressing the non-exclusivity of his pedophilia, the hearing examiner does point out that although he has expressed, this has all been his self-report, that he has this interest in females, in adult females, that there has never been an adult relationship.
But where does that get you? I think this is probably the same question that Judge Sachs just asked, which is, so the hearing examiner makes those observations, but if the hearing examiner doesn't reject the notion that he is non-exclusive, then, I mean, and I don't think the hearing examiner does reject that. And yes, there's sort of suggestions in what is written that the hearing examiner is perhaps not persuaded. But if the hearing examiner doesn't reject it, then doesn't the hearing examiner have to deal with the materials that are being presented that indicate that their risk of reoffense is much lower?
Well, I think with regards to factor one, we come back to, you have a statute and you have the regulations that address pedophilia. There, as Justice Walsh indicates, there is nothing that parses it out between non-exclusive and exclusive within that.
Just as there was nothing that parsed out
Right.
age or parsed out gender until someone said, well, you better parse it out because there's a big difference between the two.
But what I would indicate is that a person who is diagnosed with non-exclusive pedophilia fits under factor one, regardless if that pedophilia is exclusive or non-exclusive.
The argument that's being made, I completely agree with you as far as that goes. The argument that's being made is they shouldn't. Factor one should not apply because it's irrelevant in terms of whether it's an increased risk of reoffense if they in fact are non-exclusive. Here's a stack of materials from people who did social science that shows that. Doesn't the judge have to deal with the stack of social science?
I agree that the hearing examiner could have written out something clearer with regards to addressing those articles. But again, I don't think it's dispositive because factor one would apply regardless. And what you have, even if you have two articles, Your Honor, that indicates that there is some difference between the risk elevation of non-exclusive and exclusive pedophiles, you still have to deal with the fact that they're pedophiles. And on the factor one, anyone who is diagnosed with pedophile is presenting a higher risk. What you have is indicating that within the pedophiles, that if you are a non-exclusive pedophile, you're less risk than a pedophile, a regular pedophile.
No, that's not what's being represented as to what the materials say. What's being represented as to what the materials say is that person is not only less risk, they are no more risk than anyone else who's a sex offender. In other words, there's no reason to look at this factor as an increase in risk.
And then you have, again, a statute that a hearing examiner must follow and the regulations that the hearing examiner must follow that indicates the opposite. So you come with two articles now. Again, this is why I indicate the hearing examiner, it might have been best to actually address them in person.
Should we remand for that reason?
And I would indicate that that would be harmless error, because if you remand it, you get to the point where the hearing examiner would indicate that factor one would still apply, because again, they would be bound by...
How do we know that? I mean, and how do we know the hearing examiner will reach the same level 3 conclusion? This is a statutory high-risk factor. This always leads off the board's decisions, just as this is factor 1 in the statute about high risk, and it may not be calibrated well enough.
Because I would indicate, Your Honor, that here, the hearing examiner does consider all the evidence. When you look in the hearing examiner decision and the testimony, because some of this was discussed in the testimony of Dr. DiCataldo.
I can understand that if the article said someone who is a non-exclusive pedophile presents no higher risk than any other sex offender, but they have to show that they're a non-exclusive pedophile, not merely by reporting an interest in adults, but by demonstrating that they actually have a sexual interest in adults. If the article said that, then I could understand that the hearing examiner here could take a look at those articles and say, well, that doesn't apply to Mr. Doe. He's reporting an interest, but how do we know?
But the articles that were presented also does not address the fact that someone who's continued to exhibit that interest in children, that primary interest in children.
Can I back up for a moment?
Sure.
When you talked about the remand, and I have a little bit of experience in dealing with sex offender risk here. You can find 100 experts that have differences of opinion about risk factors, whether it's exclusive or non-exclusive. You put 100 of them in a room, and they all are intelligent, open-minded people that some will say high risk, some will say medium, some will say low, depending on how they approach the science. There's not like one right answer. The Sex Offender Registry Board sets up a number of factors. And when Justice Sachs asked you, I just want to make sure I understand this right. Well, hey, shouldn't we remand this so that the hearing examiner can explain why they didn't think Dr. DiCataldo's opinion about non-exclusivity should have been considered in factor one? And you said no. Because even if Dr. Cataldo has a study that says if you're non-exclusive, you're low risk, is your position that the hearing examiner must, because there's a DSM diagnosis of pedophilia, period. Hearing examiner must consider factor one, which places a high risk value.
I would say that I have seen cases where people are diagnosed with pedophilia, but hearing examiners did not apply factor one. So I think here where we have a case where the hearing examiner considered the evidence before them, and they indicate that factor one is applicable here, and indicate why it's applicable, because he's been repeatedly diagnosed with pedophilia.
Right, but if it's undisputed, he's a pedophiliac. He has pedophilia, but not into the, it's like you have schizophrenia, but what type of schizophrenia do you have? He has a mental abnormality. Is that kind of, then hearing examiner must check off factor one if we remanded?
Well, factor one indicates that if you have a mental abnormality that's connected with the sexual deviance, that they can apply that factor. I don't think that the research is going to displace the application of factor one where it's properly promulgated and is considered by statute. The hearing examiner certainly can take into account or consider the additional research that's been presented and discuss that further. But again, I do not think that that's going to be dispositive of his entire risk, even if factor one weren't to apply, because we have other statutory high-risk factors that apply here.
Okay, and that's true, but what other statutory high-risk factors apply?
We have factor two, where he...
Repetitive and compulsive behavior.
Correct, because he was convicted...
The most important thing about this particular person is that he's a pedophiliac, and that's been shown by repeated behavior. I suppose it's the two put together, right?
Well, I think it's more than he's a pedophilia, right? A pedophile. His pedophilia, obviously his interest, his general interest is diagnosis of pedophilia. But you have someone that committed contact and non-contact offenses. So we get past that you're just diagnosed with pedophilia where you're touching 4-year-olds and...
To the extent you're making, here's, the difficulty with that is to the extent you're making what sounds to me to be a harmless error argument. Basically, we can take factor one out, we're still going to consider this person to be a level 3, but a big part of why we consider this person to be a level 3 is the mental abnormality.
And I don't want to indicate that factor one is meaningless. That's not what I'm indicating, and that if you take it out, that it's definitely. What I'm indicating is, if you were to remand it, factor one would still apply, because the hearing examiner would follow the statute and would follow the regulations that indicate that that factor applies. Certainly, the research can be taken into account on remand if you wanted the hearing examiner to flesh it out more in another part and talk about that, but that does not displace the application of factor one, statutorily or by regulation.
Can I ask you about how the examiner dealt with the risk assessment tools offered by Doe's expert? On page 27 of his decision, this is Record Appendix 3, page 376, the examiner says, referring to tests like the static 99R and the RSVP, I therefore give those tests some weight to the extent each was correctly applied to the facts, and in so doing, only to the extent each may be seen as a general indicator of risk of reoffense. What does that language mean? To the extent that each was correctly applied to the facts. That seems like, well, maybe they were correctly applied, maybe they weren't correctly applied. I'm not saying, how can we evaluate that?
Well, I think what
And I understand this is language that appears in practically every board decision where an expert offers a risk assessment.
And I would indicate, Your Honor, when you look at just the risk assessment itself, the risk assessment tools, and what the hearing examiner basically is saying is whomever performed this assessment, regardless of how they, what they took into account in applying that assessment, that the result of the assessment is just going to be a generalized risk opinion.
So in other words, if a doctor, an expert, relied upon self-reporting and said, are you attracted to young children? And the individual said, no, I'm not. And they wrote 0 risk. Then you could describe that as to the extent that they relied upon the appropriate.
Right, because different experts could come to different.
Okay, so different experts can certainly come to different opinions.
Right.
But I don't understand this decision. The hearing examiner says, I give those tests some weight to the extent each was correctly applied to the facts. Did the hearing examiner discount these risk assessments because they were incorrectly applied to the facts?
I don't think they were discounted. They just indicated that they are taking them into account. So whatever the results
Well,
of.
but how do we know? The hearing examiner includes this kind of throwaway line. Well, whatever, to the extent that they were correctly applied. We don't know whether the hearing examiner discounted the assessments for that reason or not.
Well, the hearing examiner definitely does not say that they're discounting the results of that test, or that they don't believe that it was correctly applied.
Well, then why does the hearing examiner raise this question or insert this qualifier about whether the tests were correctly applied to the facts if the hearing examiner isn't adjusting the weight based on that?
I don't think it's adjusting the weight. I think it's just saying I'm taking into account these risk assessments, and to what extent that they were evaluated, I'm going to take that risk assessment as a generalized risk assessment.
What's troublesome to me, at least, speaking only for myself about this, is that we see this in every SORB decision that involves an expert, and it's raised as a way of dismissing or giving minimal weight to experts' assessments without specifying what the hearing examiner really means. And it makes it very difficult to review whether it was appropriate to discount the expert's assessment.
Well, I think in this particular case, the hearing examiner is pretty clear with regards to the other grounds why they do not agree that he's a moderate risk based on Dr. DiCataldo's evaluation, including the assessments that you discussed. I think even at the end, since this Dr. DiCataldo did those assessments, his testimony is that final wrapping up of all the information that he took into account when he was forming his risk opinion. And if the court has nothing further, I'd rest on my brief.
Okay, thank you both for your
Thank you.
All right, we'll take a 15-minute recess.
Court, all rise. open. Please be seated.
All right, thank you for your patience. We will resume with number 24P 666, Currents and Others versus AD Makepeace Company and others. And by the way, if you see us looking at our iPads when we're up here, we're not checking the baseball scores. We're looking at the briefs and record materials that are here. So we are paying attention. Ms. Sheehan.
May it please the court, my name is Margaret Sheehan, pro bono counsel for the appellants, a more than 10 residents group under the citizen suit law. The group is requesting that the court deny the motion to dismiss filed by AD Makepeace Company, Reed Custom Soils, and the Carver Earth Removal Committee. This case is about widespread damage to the environment being caused by Makepeace's sand and gravel mining. The verified complaint explains how the sand and gravel mining occurs. Trees are clear-cut, the vegetation and topsoil is stripped away to expose the underlying sand deposits that are then excavated and loaded into tractor-trailer trucks and hauled away. Makepeace uses the sand to supply its Reed Custom Soils, which it describes.
The real question here, well, at least under 214.7a, the threshold question is whether this is a law that has as its main purpose to prevent or minimize damage to the environment. How do we make that decision?
Well, you make that decision by looking at the bylaw itself, and the key provisions that I would urge the court to look at are subsections 9.1.1, the purpose clause, 9.1.5, and 9.1.7, as well as reading it in the context of the overall Carver bylaws, which include a zoning bylaw to protect the Aquifer Protection District. So I'd be happy to address those bylaw provisions to explain why they show a major purpose to prevent and minimize damage to the environment.
Not a major.
Excuse me? I'm sorry.
You saw two judges just respond instantaneously to the use of the word a major. It's the
major, correct. The major.
Okay?
Yes.
So do you agree that it can only be one? It has to be the major.
The major purpose to prevent or minimize.
Right.
Not ban, prevent or minimize.
But in other words, if there's another purpose that is more significant than preventing damage to the environment, then 7A does not apply.
Well, again, Your Honor, the language says prevent or minimize.
But I'm not sure, are you suggesting then that there could be two different major purposes to a statute or a bylaw?
Not two major purposes, just the major purpose.
Okay. All right.
So I will explain why this bylaw is like any other environmental permitting scheme. And that's because...
If you could give special attention to the definition of damage to the environment in 214.7a, and there are a number of examples, including air pollution, water pollution, improper sewage disposal, so forth. Which one of those items listed there do you think is the major purpose served by the bylaw?
Actually, almost all of them. So damage to the environment includes actual or probable damage to any of the natural resources of the Commonwealth, and that's in paragraph 1. So then when we compare that to what the bylaw actually says, you can see that all of those damage to the environment definition topics, such as air pollution, water pollution, improper sewage disposal, excessive noise, impairment and eutrophication of rivers, streams, floodplains, lakes, water resources, and historic sites, for example.
I don't understand that. I mean, I understand that all those words are there, but are you saying that that the major purpose of the earth removal bylaw of the town of Carver is to prevent air pollution?
No, it's to prevent many forms of damage to the environment, including air pollution. And
so the first thing you read interested me, which is the actual sort of introduction in 214 section 7A talks about damage to any natural resource, I believe is the language, right? Any natural resource?
It's Paragraph 1, and it's the definition of damage to the environment, which shall mean any destruction, damage, impairment, actual or probable to any of the natural resources. And then it goes on to list them.
So is there something that would tell us that stripping land that the land is a natural resource, for example? How do we define, there are a whole lot of words here, undefined in any case law in Massachusetts that I'm aware of, defined in other contexts. So where would I go to find a definition of the word natural resource, for example? And where presumably you would point me to one that suggests that land is a natural resource.
Well, natural resources of the Commonwealth are referred to here as land and water resources of the Commonwealth. It's common sense that if you are causing damage to the land, that you are damaging the natural resources, which...
Well, but we wouldn't ordinarily think of taking the land and moving it from point A to point B as damaging it, okay? If you read this as broadly as that, then every time somebody's constructed anything, put in a post for a fence, they've damaged the natural resources of the Commonwealth, they dug a hole. But help me, because we have to, we can't just sort of paint with the broadest brush that you want. We have to understand what this language means in a way that makes sense.
Well, natural resources and common sense language would include...
Common sense is not what I'm looking for. I'm looking for case law or something, some materials that'll help us define what the word natural resource means in the statute or what the word environment means in the statute.
Again, this is not just digging a hole in the ground. This is leveling vast areas of trees, stripping away topsoil, interfering with the ability of the land to protect the underground aquifer.
If they're building a single-family home and they do all those things, damage sufficient for somebody to bring a claim under 7A?
No, only...
Okay, so where are the allegations in the complaint then that make this different in kind?
Because the allegations in the complaint describe the extensive activities removing trees, vegetation, topsoil, harming historic sites, causing air pollution from 500,000 trucks, over 2 square miles, and leveling hills by 50 feet over a period of at least 13 years, at least as of the...
So what in the bylaw is designed to prevent leveling of hills by 50 feet? Just to take one example.
The precise language is in the purposes clause and in the site plan review provision 9.1.5 and 9.1.7. So these 3 provisions describe the different environmental features and features of the land that the permitting process is intended to prevent and minimize damage to. For example, in 1.9.1, the purposes clause states that the purpose of the bylaw is to ensure that permanent changes in the surface contours of the land resulting from removal and grading of earth materials will leave this land in a safe and convenient condition for appropriate reuse, not leaving the land as a barren wasteland subject to erosion and blowing sand. And also,
but it doesn't say specifically what I asked about, taking 50 feet off of the top of a hill. It says as long as you leave it in a safe and convenient condition for appropriate reuse, without creating a danger of damage to public or private property or requiring excessive and unreasonable maintenance, the purposes of the bylaw have been served.
Well, it's, again, preventing permanent changes in the surface contours,
Preventing them,
Say
ensuring
prevent.
that they meet certain conditions.
Right, and that's exactly what the bylaw does. Just like any other environmental law, whether it's an air pollution law, a water pollution law, or a wetlands law, the purpose of those laws is to prevent or minimize damage to the environment. And how they do that is through a permitting scheme, exactly like what this
Yeah, but you put the rabbit in the hat when you said, just like any other environmental law. I mean, another way to look at this is that it's a it's a law about public safety. Leave the land in a safe and convenient condition. Provide that earth removal activities shall be conducted in a safe manner. If it's a public safety law, is it an environmental law?
It's a lot more than a public safety law. It talks
Well,
about...
we get back to, can you have two major reasons? And I think your answer was no, there has to be a.
The.
Right? And so when you read 9.11, do you take it to mean that, because arguably the judge's point, whenever you move soil or sand, right, you're disturbing, you're removing. But it seems to me like the purpose of that bylaw is so you don't leave the land with that big, huge hole that maybe kids could fall into and die, right? About public safety. Now, it would be nice, too, if you didn't damage the soil and create all these other things, but is the purpose, major purpose, say you don't create a big hole in the ground that somebody could get hurt?
The major purpose is to prevent or minimize damage to the environment. And I would like to move on to the sections 1.1.5 and 1.7 of the bylaw that implements the permitting schemes. So this bylaw prohibits earth removal at a certain scale, not someone moving land around in their backyard to dig a post hole. This is about a large-scale activity, commercial earth removal. It's prohibited without a permit, and to get that permit, you have to file a site plan permit application, which is 9.1.5. It describes environmental features, and there'd be no point in describing these features of the land in this permit application statute or bylaw if the purpose was not to prevent and minimize damage to them. For example, under 9.1.5C, the permit application, that is the site plan, has to include information about vegetation, sources of water, wetlands, primary recharge areas, so that's the groundwater recharge, and when you remove sand and gravel from the earth, you are changing the ability of the groundwater to recharge. It goes on. The Natural Heritage and Endangered Species Program, priority habitat of rare and endangered species, sewage disposal, streams, ponds, final ground levels with those of adjacent properties. The permit has to indicate natural surface water flows and drainage ditches, if any. It shall show the groundwater elevations before and after removal. It has to have drainage calculations, describe the 10 and 100-year storm effects, and a fully complete restoration plan. Those are all environmental features that have to be described in the permit application so that the permit that is issued can protect or prevent and minimize damage to them. And Section 9.1.7, which is what authorizes the permit, requires certain conditions. And the conditions require that it be the correct land use. And this is a really critical factor because the earth removal, this commercial scale activity, has to be an activity allowed in the zoning district. And it requires the Earth Removal Committee to put in place monitoring and review conditions to
So,
enable.
can we, there are a host of issues here. They're not easy. I don't know what this argument goes to. Are you still talking about Chapter 214, Section 7A?
I am talking about 21470A and the extent to which the earth removal bylaw has as the major purpose to prevent or minimize damage to the environment. And I'm explaining how the earth removal bylaw sets up a permitting scheme that has a purposes clause, has a site plan review application that requires a description of all the environmental features of the land, and then how once the permit is issued, it has to have these monitoring and oversight requirements in order to make sure that the Earth Removal Committee will prevent and minimize damage to the environment.
So let me, I have several questions, I think. Let's start here. The statute applies to damage to the environment that is occurring or is about to occur. Is there, at this point, ongoing work on each of the 6 sites?
3 of the sites have ongoing work, yes.
3 of the sites have ongoing work. Okay. I thought I had other questions, but they are escaping me at the moment. Do you guys have other questions?
Is the Earth Removal Committee causing damage, or at best is it allowing damage to occur, in your view?
In our view, as alleged in the complaint, it is an active participant in giving out these permits.
Well, giving out a permit means allowing something to happen.
Right.
Are they causing the damage, or are they just failing to regulate, in your view, and allowing the damage to happen?
By failing to regulate, they are causing it, in our view.
Okay.
By failing to regulate, they are causing. Okay. So that's a legal issue for us as to what the word cause means in the statute, right?
That's correct.
Okay.
But
I got, one of the things about this claim that I didn't see in either of the other claims that have got the appellate courts from this is that, at least with respect to the sites that are where damage is still occurring, according to your allegations, there's a permit in each of those sites, right? Are there any cases about how this statute applies in the context where a permit has actually been issued to do something on the property that has to do with earth removal?
Well, all of the cases so far that we have reviewed, Henry versus Board of Appeals of Dunstable, the Old Colony Boy Scouts Council case that involved a cranberry project just like this, they were all in the cases where the town refused to give a permit because it determined that the land use, the sand and gravel mining, was not incidental to agriculture. And that's exactly the argument here that has resulted.
But see, one of the things we have to try to decide is how does this statute apply in the context where your claim is, even though you were permitted by town permit to do this, you still violated the natural resource damage problem. I shouldn't call it the Natural Resource Damages Act because that's something different. And there is a provision that gives a defense for certain allowed activities, right? There's a special paragraph for pollution that's permitted. I'm trying to figure out how this works, okay? And ultimately, and I'm afraid we're going to go long on this, you go, when they have a permit, you did what the statute requires, which is you had to give notice saying, please enforce this, right? And then your claim is they didn't. So you then bring a 7A claim. How soon do you have to do that?
Well, that goes to one of the defendant's arguments, of course, is that the statute of limitations of the underlying certiorari statute, this is a general bylaw, they're saying we should have brought it within 60 days. We're saying that the first permit was granted in 2011. It wasn't until 3 more permits were issued and the scope and scale of the operation became obvious and the cranberry projects were not built that it was determined and made manifest to the public and to the plaintiffs that this was not an agricultural excavation.
Okay, but you didn't answer my question. I'm not thinking of this, they may be, but I'm not, as a certiorari case. I'm thinking of this as a Section 7A case.
Right.
Against somebody who had a permit. Okay? And you said, enforce compliance with the permit. And you said that, I think, 3 times. The third time was sometime, I believe, in August of 2021. And you say, and nobody enforced compliance with the permit, and therefore we can bring a 7A claim, right? But how soon do you have to bring that? Forget about certiorari. Why isn't a year too long?
Because we not only said in the notice letters, enforce compliance with the permit terms, say, you know, how many quarterly monitoring reports, how many inspections they did they have a bond? No, they did not. We also said that this has become manifest, that this is not agricultural excavation under 9.1.2, the definition of agriculture. We said this has far exceeded the scope of incidental land use. This is not incidental to any agricultural use of the land. So when that became manifest and when the activity was ongoing year after year after year, now 15 years of excavation, the violations are continuing to occur of the bylaw.
But you didn't bring, so it's very helpful in the context of trying to evaluate a claim to sort of look at what is it, okay? And you say, well, it's still going, but you didn't say that in something that you sent to the permit granting authority in 2022. You didn't. You said it a year earlier. Hence my question, is this still occurring? Because if it's not, the statute doesn't apply, right? So, you know, there has to be, it seems to me, some time limit between the time you do the notice that's required by 7A and you bring the lawsuit under 7A. Is a year, why is that a reasonable length of time? Especially when we're looking at a statute which only applies, there's no damages under this statute, it's only an injunctive relief statute. It only applies if it's occurring or about to occur. So why should we construe it to allow you to go a year later?
This is a massive, massive damage to the environment case. It's 2 square miles, permits that extend since 2008. By the time everyone figured out, frankly, what was going on here, we started to essentially beg the Earth Removal Committee through a series of letters to do something about this, to stop the damage to the environment, the air pollution, et cetera. The latest notice letter was in March of 2022, and we filed the complaint in August of 2022. We took...
let me make sure. So there was a notice letter in March of 2022?
There was I believe it's Exhibit D, C or D, to the verified complaint. That was the last notice letter. We tried and we tried to negotiate this with the town, to seek redress through informal means. We were ignored. The activity continued and continued. And so there was, the last notice letter was in March.
I think actually that's helpful. Thank you.
Can I just ask, because it seemed to me that the facts as alleged were very different than, if you want to say a typical 10 taxpayer case, but that might not even be the correct term. But is there any case out there, because I have not found one, in which, in essence, you're claiming, hey, you didn't do your job here, you're in cahoots, and as a result, you created all this environmental damage. So your failure, your complicity, and your failure to regulate gives us 10 taxpayer, right? Is there any case out there that's even close to your case that we could look to say, yeah, actually, this fits?
No, there isn't, because this is a very unique situation.
Right, I agree.
A lot of the 214-7A cases are MIPA, environmental review cases. This is very, very different, and it would be a damage to the environment case regardless of whether the Earth Removal Committee was a party. So this is about damage to the environment in violation of the bylaw.
You don't actually allege that that the committee is in cahoots with, I mean, I didn't see that in the complaint. I didn't see a conspiracy allegation. I didn't see anything like that. I saw and I'm reading it now, so you're going to have to point me to it if you made the allegation that that they were acting in complicity with ADM.
Well, we allege in paragraphs 33 to 45 that the Earth Removal Committee has ceased to function and ceased to do its job. We also allege that the Earth Removal Committee members have economic interests and business interests with AD Makepeace.
Neither one of those is an allegation of conspiracy. Can you agree with me about that?
Excuse me?
Neither one of those, none of what you've identified, is an allegation that there is an agreement or a conspiracy.
True, but it goes to the need for this court to allow this case to move forward so that the citizen group can step into the shoes of the Earth Removal Committee and enforce the bylaw. That's what this is about. And we tried to get enforcement. We were unsuccessful. Now someone needs to enforce the bylaw so we can try to prevent and minimize the damage to the environment.
All right. Thank you. We've kept you up here a very long time.
May I do a brief conclusion?
I think we're going to have to leave it there.
Thank you.
I'm sorry.
Thank you,
But we've
Your
read
Honor.
your brief, and we will read it again very carefully.
Thank you.
And your reply brief. So, Mr. Pontrelli, for Makepeace, 12 minutes, do I understand correctly?
Yes, Your Honor.
Yes.
Thank you, Your Honor, and may it please the Court. Before I get to the legal issues that Your Honor's been asking questions about, I'd like to clarify two factual matters. I heard widespread damage, and I heard massive, massive damage. There was a preliminary injunction proceeding in this matter. In connection with that, the court made a number of findings and conclusions that I commend to Your Honors. One of them was that as to...
Record?
Excuse me?
Is it in our record? I saw no reference to this in the briefs.
Yes, there...
In our record.
Yes, it is in the briefs. Under the section that involves whether there was alleged damage to the environment, in the introductory paragraph of that argument, we cite to the trial court's conclusion in its preliminary injunction ruling, which is in the addendum, that as to harm, plaintiffs had failed to demonstrate, quote, any concrete harm, close quote. So that doesn't go to the Rule 12b-6 standard, but to the extent we're talking about...
Was there an evidentiary hearing?
There was not. It was decided on affidavits, Your Honor.
Okay.
And the second point Your Honor asked about whether any work was going on, there are 3 sites, as opposing counsel said, where there is excavation going on pursuant to permits. The other 3 sites, excavation ceased long ago, and since then, there are solar power facilities operating there, ironically, to help alleviate the perils of climate change. But getting to Your Honor's questions about the major purpose of the bylaw, I think what I would first say is that the earth removal bylaw regulates the permissible extraction of natural resources, not the protection of those natural resources. And in particular, the text of the bylaw, which I think is the
Well,
most...
it's about extraction of some, but there's more environment left once you're done extracting. And the earth removal bylaw certainly is directed to what condition that environment is left in.
True.
Surrounding area. So
True.
it's not just about what you take out and what you do with it.
True. I think it is significant, though, Your Honor, and we have a section in the brief where we point out that unlike other environmental regulations, including the other portions of the environment chapter of Carver's, earth removal has been around a long time. And it used to be done with no regulation.
Okay. Maybe even before we had an environmental movement or anything like that.
That's correct.
But that can't control. I mean, we've had air pollution regulations for a long time. I mean, for many, many decades, going way back before the 1960s. But I assume you would agree that air pollution regulation would fit within 214(7)A.
Yes, I would.
Okay. So how do we decide?
All right, getting back
And in
to...
particular, can we take the statement of purpose as dispositive, as controlling, or don't we have to look at the substance of the types of regulations that are authorized?
I would not say dispositive or controlling. I would say that this is the administrator or municipal equivalent of trying to interpret a statute or trying to interpret a contract. That it's the best place to start, and I think in this case, may be the place to end. And what I wanted to say further, Your Honor, because I don't disagree with you that, yes, there is regulation of extraction. That regulation is designed to deal with an array of risks posed by earth removal, an array of risks, and then, as Your Honors were pointing out, to return to the land to a safe condition afterwards. And it's that array of risks which I think is the most important thing for you to consider.
Not just return it to a safe condition. It's return it so that it can be reused.
Yes, Your Honor.
Okay.
But that's not to say, Your Honor, in terms of reuse, that you've got part of the natural environment that you're somehow protecting. It's not like you have to put back the trees that were there before, which is the type of remedy that you'd be talking about in a 7A case. So I would say that the idea there is safe condition. That's the language of the statement of purpose. And as I was about to say, when I talk about many risks, we're involved in a lot of litigation down there in southeastern Massachusetts. And what those other cases that are down there are about, when you have people living next to these sand and gravel operations, in the complaints alleged by...
I thought they were building a cranberry bog. I didn't think it was a sand and gravel operation. Is it a sand and gravel operation?
It's a sand and gravel operation right now, Your Honor. They are building a cranberry bog. And as to the point that Your Honor mentioned, the construction of the cranberry bogs can provide an exemption from getting any permit at all to do sand and gravel work. It can provide an exemption. Makepeace hasn't relied on that. They have obtained permits so that they are allowed to conduct sand and gravel operations on these sites and then dispose of the sand and gravel. They use some of it themselves, they sell some to other cranberry growers, and they sell them to governments and to private businesses. They're allowed to do that under these permits. So what I was going to say further, though, is that in terms of the other cases that are pending and the complaints about the sand and gravel removal, is the complaints are, it's noisy, it's dusty, the trucks on the roads are bothering me. It's a problem for the residents generally in Carver, and those are the sorts of things.
So you're familiar with the decision in Beard, right? You both...
Yes, Your Honor.
So what you're saying, I'm right where Judge Sachs is, which is how do we decide what these words mean? How do we decide what natural resources means in the statute? How do we decide what environment means in the statute? You're taking this narrow view. She takes a broader view. Beard, it seems to me, sides with the plaintiffs on this one, right? The stripping of the topsoil from attractive land is not only likely to produce disagreeable dust and noise during the process, which may be prolonged, But more important, after it's completed, it leaves a desert area in which a long period of time little or nothing will grow except weeds and brush. It permanently destroys the soil for agricultural use and commonly leaves the land almost valueless for any purpose. They said this, they quoted this, the SJC, in connection with this problem, removal of earth. That sounds like the environment to me. What am I missing?
I'm sorry, Your Honor, the SJC?
I think so. I'm reading from footnote 8 of Beard against Salisbury, written by the Supreme Judicial Court of Massachusetts, addressing a question having to do with the removal of earth. It sounds like they're concerned about the environment.
Well, Your Honor, you asked earlier about the permitting scheme and what the permits allow. As I was trying to suggest earlier, we have earth removal bylaws all across the Commonwealth since 1949. Now, Makepeace isn't the only one extracting sand and gravel to build cranberry bogs. They're definitely not the only ones doing it for other purposes. The suggestion here goes too far in that a Section 7A action would be available with respect to every single time anyone is extracting sand and gravel. And so I would say...
Really? I mean, first of all, it has a de minimis exception, right? Specific one. It says, damage to the environment shall not include any insignificant destruction, damage, or impairment. So my post example, that's the answer to that. And probably that's the answer to, building a single-family home. But that's not what we're talking about here.
Well, Your Honor, I'm trying...
That's what Beard is talking about, it seems to me.
I would say, Your Honor, that to get back to where the court started with what the major purpose of the bylaw is, that is, what the statute says, as we were talking about earlier, the major purpose has to be to protect the bylaw, to protect the environment, natural resources.
To prevent or minimize damage.
Yes,
Can
correct.
I direct your attention to 9.15C? I mean, if that's not environmental, I don't know what is. The plan shall include but not limited to vegetation, existing and proposed roadways, location of sources of water, wetlands, primary recharge areas, endangered species, et cetera, the site plan. It seems as if within the town of Carver's subheading of environmental, under which 9.15C is underneath, sounds environmental to me. Sounds like that's what they're getting at. Because if you scroll down, there are exemptions for the very earth removal conditions exemptions, 9.18, when there's 200 to less than 1,000 cubic yards for multifamily or commercial project, the posting. But how do you get around when you look at that particular requirement that you have to do, which is to consider wetlands, to consider all these other kind of environmental impacts of digging?
I agree that that information has to be supplied. Even that information pertains to things other than the environment, such as the roadways, because the big issue is the truck traffic on the roads. So it isn't just environmental features that are involved there. But more to the point, the ERC is still supposed to be taking into account all of the impacts on the surrounding community, which are impacts, as I've said, other than just environmental impacts. And I would suggest if the court's looking for case law on this, the Fellsway case, which is cited in our brief, and the Glazer case, which is cited in the trial court's...
They're going to help us how?
They're going to help you because these are cases in which the courts recognize that there was an environmental component to the relevant law, but that there were other components to the relevant law that made them...
What is the other component you would say there is here?
The other components here, Your Honor, aside
Are
from...
the major purpose, right? They've got to be the major... They've got to, if you will, they have to supervene the environmental purpose if there is one.
That's correct, Your Honor. And what I would say is that The bylaw is instructing the ERC to consider the health and safety of Carver generally, and then restoring the land to a safe condition. And with respect to those risks, what you have are things like noise and dust and truck traffic, along with the environmental considerations. It's a multifaceted approach, which again...
Noise and dust are environmental concerns.
They're environmental concerns, but you're not talking there, Your Honor, about protecting the environment and natural resources. You're talking about an impact on the residents of the citizens of Carver. No one cares about the dust and the noise in and of themselves. Then there's no natural resource being harmed in that regard.
Can you just tell us where the Fellsway case and the Glazer case you mentioned? I'm not seeing either of them in your table of authorities, so. I recognize the Fellsway case, but not the Glazer case.
Yeah.
I'm sorry. I mean, now is the time to figure this shit out.
For some reason, it is omitted from the table of contents, but I will give you the page reference.
Well, if you can send them in a letter afterwards, why don't you do that?
All right, Your Honor, I'll do that.
Yeah. We don't want to take up too much more time, although we do have a lot of
I
questions.
understand.
If you'll just follow me for a moment.
Yes, Your Honor.
Because your time is up, and my chief is telling me I got to wrap this up in a polite way. Let's assume that we don't agree with you and that we think the major purpose of the bylaw falls within 7A. Can you still win, and where would you send us? So I understand the argument 4, 5, and 6 not occurring, got that one. What else? Is there a way for you to still win?
There are 4 ways, Your Honor. One way is subject matter jurisdiction, and the other way is statute of limitations. As to statute of limitations, if I may, Your Honor, I would direct the court to the EarthSource decision of this court, which says that as to a 7A action, whereas Your Honor was getting at, it's not like there's a statute of limitations. You're supposed to look to...
Is it true that the last demand was in March of 2022, so 5 months before suit was filed?
That's not quite correct, Your Honor. The last demand of the ERC was in June of the prior year. In August, there was a notice letter under Section 7A with respect to the 10 persons group. And then, fast forward to the following March, there was another notice letter with respect to the 10 residents group that then became the plaintiffs in this action.
Last time that that enforcement was demanded was in June of 2021?
Yes.
And the other letters, if I go back and read them carefully, are not going to be demanding enforcement anymore. They're simply the notice that we're going to be able to sue 21 days from now.
Yes. And as I was about to say, what the EarthSource decision says, because there isn't a statute of limitations, is that you look to the statutory scheme that concerns the alleged legal violation. And in this setting, what you're talking about is this demand, this final demand, the demands that were made of the ERC through the prior spring, and the decision of the ERC in June to decline enforcement.
That's not subject to certiorari, is it?
Yes, it is.
That's a quasi-judicial determination? A refusal to enforce is a quasi-judicial?
Yes, Your Honor.
What case would you cite me to for that?
The only case we have specifically on this point is the O'Brien case, and then our case in terms of how the statute of limitations is supposed to function. I don't have an...
No, but you understand you want to tie into the 60 days on certiorari, but certiorari only applies to a quasi-judicial decision of an agency.
Yes, and that's what I
There
would...
are cases about what a quasi-judicial decision of an agency are. This is just a flat-out failure to enforce. You made a demand, enforce, they refused to enforce. I'm not sure that's a quasi-judicial decision.
What I'm suggesting, Your Honor, is that whether or not it's a quasi-judicial decision, it's the closest thing in terms of picking a statute of limitations. There's really no reason.
It's analogous.
It's analogous.
We should borrow it.
There's no reason to pick any longer one, as Your Honor was
Does
suggesting.
that serve
What
the
would it be?
purpose? Is that consistent with the purpose of 214-7A, which is to allow 10 citizens to try to prevent or minimize damage to the environment? If you don't catch them within 60 days, then you're out.
In the Earth Source case, it was 30 days, Your Honor. So it happens. And it's not unharmonious. If you're concerned about what's going on somewhere and you ask for enforcement and you don't get it, there's really no reason not to go ahead and just sue.
Except the 21 days you got to wait, right?
But again, the idea with this 21 days is...
They got to match, they got to get in with between 21 and 60 or they're out of luck.
Let's put it this way. 60 days is plenty of time if what they're saying is, with respect to emergency, temporary relief, you're supposed to give 21 days notice. You're not supposed to wait a year.
That might be it for me.
All right. We'll hear from the ERC.
Thank you, Your Honor.
Thank you.
Thank you. May it please the Court. I'm Amy Quessel. I serve as Town Council for the Town of Carver. I'm representing the Earth Removal Committee. I just had a few points. I'll be very brief. Essentially, there's some misstatements regarding the Earth Removal Committee. The Earth Removal Committee is fully functioning. It is doing its job. It is just simply not doing exactly what the appellant would like. They, anytime that there was a complaint, they went out, they looked, they found out that there was no enforcement that needed to be taken, and therefore that's why any mandamus should not be entertained by this court, because it had already been investigated, it was already complete. Permits were issued. There was monitoring involved in the permits, and that monitoring was sufficient. So with regard to a few of the things that was brought up regarding 214 Section 7A, with regard to the damage to the environment and what would be the natural resources, in my opinion, it's right in the statute where it says destruction, damage, and impairment, and then it goes on to state, and it says rivers, streams, floodplains, lakes, ponds, or other water resources, destruction of seashores, dunes, wetlands, open spaces, natural areas, parks, or historic districts or sites. Those are the natural resources.
It says including but not limited to, and several of those, I underlined it when I went through, and I said, boy, those sound like the kind of things that the SJC was concerned about in Beard. Open spaces is one of the things that's listed.
Correct, Your Honor.
Okay, so why isn't that what this bylaw is about? It's about protecting against what can happen when someone removes earth.
So it is regulatory, and it's essentially the main purpose of the earth removal bylaw is the health and safety. It is not protection of the environment.
Wouldn't you say the major purpose of a law to try to control air pollution is health and safety?
I think that would be more of an environmental issue rather than health and safety.
Okay, but just because you say just because you say it's health and safety doesn't mean it's not. I mean, the damage to the environment can cause health and safety issues.
Correct. However, in the earth removal bylaw, in the purpose section 9.1.1, there's absolutely no reference to the word environment. It is the health, safety, and general welfare of the residents of the town of Carver. And I think that...
Section 9, though, is under the subtitle of, it happens to be in caps, environment. Just saying.
That is the chapter, Your Honor.
Somebody put the word environment over the top of this.
This actually,
Carver.
this document actually has been recodified, but yes, you are correct. It's right there in black and white. However, if you read the entire earth removal, the purpose of it. The purpose is to protect the general public from this earth removal, from these earth removal operations. Furthermore, if you go to 9.5.1C that Your Honor had referenced, there's also other things that are required for the filing, which is sewage disposal, parking, loading, access, easements, rights-of-way, walls, fences, ditches. It is not just it's not just the natural features.
We're going to go on way too long here. We already have, and it's my fault. But let me ask you this. I'm going to ask a similar question what I asked your brother. Let's assume we don't agree, and we think the major purpose of this is protection against damage to the environment. How do you think 7A works when you have a permit? So, I mean, there's no case law on this, right? So it seems to me that you have to make a demand, and they make a demand on the entity that's responsible for enforcing it, which is your client, right? But in a context that's different than the cases, because you've permitted this person. So does the statute allow the Superior Court to supervene the conclusions of your client?
So, Your Honor, I have a bit of a different opinion on all of this, which is that notice was served on the ERC, and the ERC did an investigation and responded. Therefore, in my opinion, 60 days starts when that response came back, and they were not happy with that response, and that did not happen. So, in my opinion, the certiorari 60 days kicks in.
Can't they, if it's ongoing, can't they do it again? Can't they say, oh, the nature of this has changed, so we're gonna make another demand?
So, Your Honor, we would end up in a Fisher situation with the 40A section, the 40A section 15 and 17, where every time somebody complains and appeals to the ZBA, they can keep doing that, which unfortunately could be the situation.
Is that what Fisher says? You can do it, right?
Yes. And
thank you. That's helpful, because this is what we're searching for, at least that I am. I'm searching for, it just seems to me there are a host of questions under the statute totally unresolved. Anyway, thank you.
All right.
Thank you.
Thank you very much. Thank you. Very interesting and difficult issues. Incidentally, I think I've found the citations to Fellsway and the Wellfleet versus Glaze case, so no need to write in, and I'll share them with my panelists. All right, well, thank you to everyone else in the courtroom for your patience. As you can tell if you're listening, these are difficult and potentially broad-ranging issues, so this is our only chance to try to explore them. All right, thank you. Our next case will be 24P894, Greg B. FOWKE, I hope I'm pronouncing that right, versus KATHERINE HOLLAND. And just to remind counsel, this is an partially impounded case, so this is partially impounded, so let's not use the name of the child.
Great, thank
or
you.
Any other identifying details if we can avoid it.
Whenever you're ready. Good afternoon, members of the panel. May it please the court, I am Pasquale DeSantis. I represent the appellant, KATHERINE HOLLAND. Your Honor, this is a matter over the parenting of a child. It is our position that the trial judge erred in not awarding Ms. Mother shared parenting time. The court awarded shared legal custody to the parties, left the parenting schedule as it was during the pendency of the action, where Mother had Tuesday, Thursday, afternoons and alternate weekends, Friday to Monday. Also, the judge erred in establishing a vacation schedule. In this case, what the judge failed to recognize, Your Honors, is that the mother, since the child was born, had primary or at least equal parenting time. And during the period of COVID, she was home, homeschooled, or did the remote learning with the child, etc. The underlying focus, what the judge failed to do, is to look at all of the relevant factors to determine what is the best parenting schedule. And the starting point is what existed prior to that. Did mother have equal to or greater parenting time than the father relative
Why
to the
would we
child's
start
care?
there? Why wouldn't we start where they were after the mother brought the child back and the temporary order indicate, put the child in the father's home, basically, and it was essentially the same plan that was eventually ordered. Why wouldn't we start there as what?
Sure. Judge, that was a temporary situation. In the case when it started, when it first went into...
It was temporary for 2 years.
Right, Judge. That's correct. And that should not...
Child from age, what, 9 to 11 or 8 to 10?
The child is now 11 and a half.
So
that time was about 10 or 9 and a half.
A little younger, right? So you got a young child, and for the 2 years before trial, the parenting plan was what we currently have. Why wouldn't that be what we look at as the starting? Why wouldn't that be what the court looks at as the starting
Certainly,
point?
Judge, you have to look at the historical care for the child, not just this artificial period. Now, this artificial period started with, as you see in the record, mother was away in South Carolina and she returned. The parties agreed to that schedule, and it was supposed to be very temporary. In fact, they agreed that mother would enter the ad care program, would submit to SoberLink testing, and that they would revisit this.
But didn't the mother, so there's a piece of this I didn't get the answer to, which is I think the mother sought to change it. So that was entered in, I think, September of 2020.
September 6th of 22, Your Honor.
Okay, and then in November, the mother goes to change it, right?
And
unsuccessfully, apparently.
Right, but in between, the plan was, if you read the record, Judge...
My point, counsel, is it may have been that it was supposed to be temporary, but apparently the judge made the decision to continue it or extend it. I didn't see anything about that decision or whether there was an order that came with it or anything. Was there?
Judge, the judge denied the mother's request to move it to an equal parenting plan at that time. But the idea was that that's what it would be. When the parties entered into this temporary order, it states there's a review. They will review it. And the point was to initially, father claimed he had missed some parenting time during the summer of 22, was to have the father make up that parenting time, have this review, and then it would be the shared parenting. And it wasn't. The judge did not act on it. And
the judge didn't act at all, or the judge denied the request?
Denied the request, if you will, Judge. And in these cases, the focus is, the happiness, welfare of the child. Did anything the mother do detrimentally impact the child, adversely impact the child? There are no findings, either by the guardian ad litem. The father told the guardian ad litem that there was no concern about the mother's care for the child. There are no findings whatsoever that mother did anything, including when she had used alcohol, that in any way impacted the child. These are the findings.
But I don't, can I just interrupt? That's not the findings. So I understand your argument, but look at page 15, finding number 93, right? The evidence supports a finding that mother clearly developed a drinking problem and that it went far beyond social drinking. It was serious, it was downplayed, and it impacted her ability to safely co-parent the child. I mean, I understand your argument. It just seems to me that there was a trial and the judge believed father and was concerned about the failure of mother to recognize what potential impact her alcohol use could have on the child.
But Justice Walsh, but there are no findings, like, for example, FOWKE's mother drank on this day, and this was the result to the child. The child was left unattended, or
Really,
something else.
we can't infer that from the set of findings that I'm looking at on page 4, findings 23 through, wow, at least 30. I mean, the judge lays out an event that occurs. The child is hysterical, crying. Mother is observed to be under the influence.
Is this the June 18th of 22?
July 6th? No, I'm sorry. Yeah, June 18th, that's it.
Right, right. And the child related to the guardian ad litem that she had no concerns, that had no knowledge of any alcohol issue. Now, the judge did not accept that. The guardian and...
But now you're arguing with the finding. I mean, these are the findings of the judge.
That's correct, Your Honor. Now, she stressed certain findings. In this case, what the judge focused on was the alcohol and the mother's non-employment for reasons for not granting mother the shared parenting time.
It wasn't the fact, I just want to take issue for a moment. When I've read it a few times, it appeared that the judge credited your client with having a significant period of time in which she tested negative, and that there were no issues, that she was sober during this entire testing period for thousands of tests. What the judge was concerned about is that when the stressor was the father, and there was no track record of how mother would do if she was working full-time and co-parenting and having to interact with father when she doesn't acknowledge that she has a alcohol dependency, how she could evaluate that.
Your Honor, she acknowledged the alcohol to the guardian ad litem. She acknowledged it in her questionnaire to the guardian ad litem.
When I say acknowledge, I don't mean saying, oh, yes, and I also went to the hospital because I had a few drinks. That's not acknowledging that you have a substance use disorder. Right?
Your Honor, if I may, she did the ad care program. Prior to going to court, she voluntarily submitted to SoberLink testing. Did the ad care program, 10-week, 3 times a day, intensive. She succeeded in that program. Thereafter, she voluntarily continued in individual counseling and in a recovery group.
At trial, though, the judge found that she minimized or didn't accept. And so you can go to all the programs in the world and you can test negative 2,000 times. But if you have a substance use disorder and you don't recognize it, isn't it fair for the judge to consider that may impact her ability to be spending equal time with her child?
Your Honor, the findings do not support that. Look, the mother, the testimony, all of the findings show that she drank socially, she drank sometimes at home, the parties drank together. The few times, back in 2016, there were 3 incidents where then coming forward, the father raised concerns in 2021.
But finish that sentence. In 2016, there were 3 instances in which she was hospitalized.
That was in 2016.
I know there was some time there, but that's significant, correct? And then?
Yes.
Okay.
So we say, Your Honor, she, instead of looking at all of the factors that one would look at to grant shared parenting time, the judge focused on the alcohol, and as the court is indicating that seemingly the judge thought it was diminished. It wasn't, Your Honor. Neither the father nor the guardian ad litem, nor anyone the guardian interviewed, school personnel, pediatrician, indicated that mother had an issue, or mother's care of the child harmed the child in any way. So there's no finding of danger to the child. Your Honor, if you look to, there are two 128 decisions out of this court, the Gelaro case and the Chesso case. Facts are very similar. In one case, mother had addressed her alcohol use. In both cases, mother had addressed her alcohol use, and mother was granted physical custody in one case, and the other they were granted shared parenting time. In each of those cases, the court found that mother had addressed the issue. Here, the mother submitted to 2,920 tests, all of which were negative, and the judge, instead of commenting on the positive things that she did, it was, well, mother missed several visits, or the counselor doesn't understand how the counselor could have found that the mother at that time, when she was in treatment, was not having any issues with alcohol and the like. It's none of the positive things that mother did were taken into consideration. Rather, the alcohol and the unemployment are the factors that are stressed. Rather, and under all of the case law, Your Honors, it's the child's happiness and welfare, and if, again, the history of the parenting, and unless there's some significant factor that adversely impacts the child and has adversely impacted the child, there should be shared parenting.
Well, there is shared parenting. What you mean is there should be equal parenting time.
That's correct, Your Honor. And
is there a case that says what you just said? Is there a case that says that the presumption is equal parenting time?
There's no presumption in Massachusetts. The standard, as we know, is the child's best interest. But in getting there, when the parties they're on an equal footing, Your Honor. They're on an equal footing under the statute, 208 31, that's also in the paternity statute. They're on an equal footing unless there's something, as I indicated, dramatic or significant that is harmful, has been detrimental to the child. Short of that, then court would find it's in the children's best interest to have the shared parenting. And again, I would cite the Chafaro in the case. Look, the custody cases, Cali, and the Zia, custody of Cali and custody of Zia cases speak to the standards. So here there was an undue stress by the court, Your Honor, on this alcohol issue and the lack of employment.
Can I ask about that? Do you view the judge's statement in the last paragraph of her findings about seeking modification, do you view obtaining full-time employment as a precondition to seeking modification, or could you seek it any time?
Well, as to that specific item, Your Honor, it can go either way. You can argue it either way, Judge.
How are you and your client going to view it is the question.
We would have to argue that, look, it's restrictive. It appears restrictive. I would argue that, okay, it's not restricted. She would have the ability under the modification standard, the material change of circumstance. Any material change in circumstance should be sufficient to file a modification. The way that is framed, it seems to limit. Mother must first get employment, full-time employment. Two, then must indicate that she is stress-free while having full-time employment and parenting the child. That's problematic.
I gather you haven't sought modification at this time.
She has not, and I would say since then, Your Honors, I know it's outside the record, she has increased her hours at work. She has been actively looking for employment and continuing to do all of that she did prior to the parties' separation.
All right, thank you. I think we have your argument.
Your Honors.
We'll hear from counsel for the father. And maybe you could tell us how to pronounce your last name, Labbe?
Yes, thank you, Your Honors. Candace Labbe.
Labbe.
It's a difficult one, I understand. For father here, Your Honors, may it please the court. I would like to address some things, Your Honors, first, in response to my brother's presentation. So I just want to clarify that the parenting time here, the facts are, and the court's findings are that the parenting time was not equal commencing the trial. So I think it's incorrect. In Mother's brief, she says it's uncontroverted. There was equal parenting time. As Your Honors have pointed out, not only was there a stipulation of the parties, an agreement of the parties to have shared parenting time in the way that the judge did order at trial in September of 2022, with, I would point out, no caveat in there that there was an intention that it would ever be an agreement for eventual equal parenting time. It was a review, but it was a review so that it could be redetermined with no intention of what that would be. It would, again, the review is the purpose
Then in November, Mom asks for a change?
Yes, Your
and
Honor.
that's denied?
Yes, Your
After
Honor.
a hearing?
That's correct, Your Honor. I believe
An order? Is it in the record?
it is in the record, Your Honor. I believe there were 3 different motions Mother did bring during the pendency of this litigation for equal parenting time. And I believe there were, the orders are in the record, Your Honor, in the Record Appendix Volume 1. Eventually, after several motions, there was an order for the court to bring no further orders before the court shortly before trial. But again, this was all addressed at trial. And then going back to the second point with equal parenting time, from 2021, and it's in the findings as well, although when the child was born, up to about that point, the parties had approximately equal parenting time and responsibilities and were living together, the court finds father credible that he was taking on more and more parenting time for the child. He had more responsibilities. Mother was withdrawing at that point, and then in 2022, he even increases even more. So again here, this is not uncontroverted. That's simply not true, that prior to commencement, they had shared parenting time.
May I ask about the employment issue?
Sure. Yes, Your Honor.
I understand your argument about how there could be a nexus between, or how the judge may have found a nexus between past alcohol abuse and the best interest of the child. But what about the statement that the court hopes Mother will be able to establish a record of full-time employment? Why does that have a nexus to the best interest of the child? I mean, if the mother were engaged in full-time volunteer work, or doing nothing but maintaining perfect sobriety, why should employment be a condition?
Yes, Your Honor. I think it's solely because that was the intention. Those are the facts at trial. So Mother had testified at trial that she intended to be imminently employed, Your Honor. That was something that would obviously be something the judge learned about. That would be a considerable amount of time and stress on Mother. And I think that the findings here don't go to the employment itself. I think it's just this new stressor that is untested that the court could not, there was no evidence on. And as the court finds, there was time. Mother had indicated she was seeking employment throughout the entirety of the case, Your Honor. She had declined employment, and this was just something, another issue that, Your Honor, is that the court could not find in terms of the best interest of the child.
So let me see if I understand you. If the mother were about to take on a full-time job and had established an excellent record of sobriety up to that point, but hadn't been tested yet in the crucible of full-time employment, then the judge might say, we got to wait and see. I'm not going to change things just yet. But if the mother said, I'm changing my plans, I'm not going to look for full-time employment. I'm working a little bit part-time right now. That's all I'm going to do. I'm perfectly sober. Could the judge, I mean, would the judge be able to say, no, you need to get full-time employment before we can equalize parenting time?
No, I don't think that's what she's saying. I think under these circumstances, again, it's not penalizing mother because she's not employed. I think it's just that there's this concern of this imminent employment, which mother throughout the litigation and at trial confirmed, and that this would be an additional stressor, in addition to the other stressors that the court did point out. For instance, that father is a trigger, and the ad care records for mother's alcohol treatment program, father is a trigger to mother for drinking, and again, they have to co-parent together, or that she has an emotional reaction when she sees father. So there are several issues like that, Your Honor. I do want to point out, too, in terms of the law...
It is an odd statement, don't you think, at the end of that? I mean, it does suggest that a condition to getting a modification is getting employment.
Well, I don't think that the judge made it the absolute condition. As my brother pointed out, it's the standard for modification is a significant substantial change in circumstances, so mother would meet that. This is one way that I think the judge found in her reasoning. There was a hole here that her findings, her broad discretion was that this is one reason why it was appropriate to order the parenting schedule that she did, but I don't think it's solely the employment, Your Honor.
Do you think that the judge appropriately and satisfactorily, let's forget appropriately, satisfactorily addressed the key question, which is the child's best interest?
Yes, Your Honor.
And where am I going to find that? Because your brother says, and there's some force to it, that the judge spent almost the entire time trying to work their way through the alcohol issue. And I didn't see what you often see here. You know, the child is X years old, the child has spent this much time with father and mother, I've considered equal parenting time, I've decided against it because of A or B. None of that's in here.
Well, not expressly, Your Honor, but in her findings, there are several other factors. It's not just about alcohol, Your Honor. That's obviously a serious concern here because that was a serious fact and issue in this case. But the mother considers, the judge, considers several things such as the parties' living arrangements. She points out that the child was comfortable, had friends, he had a stable living environment, and also points out in her findings that mother was renting and was receiving money at the time from her father to pay for this apartment, and there was no indication, there was no facts entered by mother to when this would continue and for housing stability.
So that would be a reason to give the father more parenting time, that the mother's housing was unstable?
Well, Your Honor, so the judge here can...
In the context of our DCF cases, I don't think that would fly. I mean, you know, that kind of reasoning, you know, yes, she has an unstable potential home situation, but that means she doesn't get to see her child?
Well, no, and there wasn't a finding that she doesn't get to see her child.
Well, I know, but you know, what do you say to your brother's concept that equal parenting time is where you should start, and moving off that requires some special, you know, occurrence?
Sure. So the law is clear in the Commonwealth, Your Honor. So under Chapter 208, Section 31, there is no presumption for or against shared physical custody at the time of trial, Your Honor. And that's only exception is when there's abuse towards the parent or child subsequently, which doesn't rise to that level here. So there's no presumption. And it also states that the rights of the parties are equal, which is what my brother has pointed to. But the case law shows that they're equal in terms of how they're evaluated going in. They're not necessarily equal after all the evidence has been presented at trials. It's not a presumption that these parents will have equal parenting time. It's discretion of the court, and it's the best interest of the child here. And again, the courts have broad discretion there and can look at a multitude of factors. It's really not limiting. And there's no specific factors. So again, the judge here, I think, appropriately zeroed in on the issues. And again, it's not just alcohol issues. But there is, she did not have to start with 50-50. In fact, that would have been incorrect. She had to look at the situation and the facts in this case and determine the best interest of the child. And I'd like to also point out, In terms of the findings, so the judge also needs to be given deference here to the opportunity of the trial judge to observe the witnesses and the credibility. I would like to point out specifically, it's in Record Appendix Volume 3, page 552, Your Honors, that the trial judge at one point stated in witnessing mother's testimony that she's all over the place, I can't even follow half of it. I mean, there was definite presentation in terms of the credibility of the witnesses here, which I think feeds into her findings as well.
All right. I think we have your argument. Thank you both very much.
Thank you, Your Honors.
I think we're going to take a very, very short break, 5 minutes or less, and we'll be back for our final two arguments.
All right.
session. Please be seated.
All right, we are back in session. Again, thank you for your patience. This is quite an unusual day. We have had 7 arguments today, which is one more than usual, and some very complicated cases. We appreciate your understanding. I will say this is the longest argument session I've had in my close to 9 years on the court, so we usually try to keep trains running more on time. With that, I will call 24P882, NASSIF versus NGUYEN. I hope I'm pronouncing those correctly.
Good afternoon, Your Honors. Michael Girardi for the appellant, Michel NASSIF. As you know, the question before the court involves the doctrine of collateral estoppel and the preclusion of issues already litigated in a prior criminal case in which there was a conviction.
Yeah, I want to ask you, how do we know that the absence of justification or excuse was actually litigated in the criminal case?
I would point to Norrington, where it says the elements of the crime are considered to be actually litigated.
Right, but the elements of criminal, was assault and battery or just battery?
It was a battery, but
whichever the criminal charge was, I looked at the elements and I did not see absence of justification or excuse as an element. I can understand that if the defendant asserted self-defense, then it would be up to the Commonwealth to negate beyond a reasonable doubt some element of that. But I can't even tell whether that happened from the record that we have before us.
Well, so in the civil trial, there wasn't dispute on that point. It was accepted in the final pretrial conference, and then right before the jury was impaneled. So if there was dispute on that, I would have expected it to be settled before then. All the parties and the judge were in agreement that the fact that force was used, that it was intentional, and that there was no justification or excuse had been litigated, and that it shouldn't be at issue in the
So
civil
then,
trial.
with respect to the intentional infliction claim, why isn't the question of who threw the first punch relevant?
It could be if it was a sole claim. I think that's the question before us, is when there is one issue already litigated, and then there's a second claim where the elements do not match, how to apply the doctrine of collateral estoppel in that scenario.
In theory, one could ask the judge for a limiting instruction saying when the defendant offered evidence on how this started and claimed that the plaintiff threw the first punch, you should consider that only on the intentional infliction claim. Do not give it any consideration whatsoever in deciding what the damages are from the assault and battery.
So I think that could have happened in the trial. As you know, on the record, the trial judge ruled instead that both parties were entitled to relate the facts as they recalled them broadly. There was no limiting instruction.
Was there a request for one?
There was a brief argument in which the plaintiff's counsel argued for the basic application.
Did you try the case?
I did not, no.
Okay.
So there was no request for a limiting instruction?
Not per se, but it was a brief argument right at the beginning on the morning of the trial.
Right. And if the judge had given the kind of limited instruction that I was outlining, would that be sufficient to prevent prejudice?
It could be, depending on the specifics of the limiting order and what counsels would have argued.
Judge Sachs is getting at a problem in a slightly different way than I was thinking about it, but I think he's right on the right track. I mean, the problem for the plaintiff here was that the two claims were joined. If the plaintiff didn't want the problem that arose just before trial to happen with respect to the battery claim, the plaintiff could have asked for severance, said it's too prejudicial to me to allow the evidence that's going to come in with respect to. I mean, it seems to me you have to win the argument that that evidence could not come in on the intentional infliction of emotional distress in order to win this appeal.
Well, I believe.
You follow me?
I do. I still think that the defendant had wide latitude to argue specific aspects of the incident. The outrageousness in particular, the severity. The reply brief pointed to specific mention of an object possibly being used in the assault. And that wasn't one of the elements. So that could have come up, and that would have been fair game to discuss at trial. It's just justification, and even a broader justification or excuse for parts of the incident. It's just in relation to the force, that was intentional, that part couldn't be excused. And his justification or excuse touched on the core interaction between the two, the physical contact.
Even if I accept that, even if we ignore that no limiting instruction was made, that no motion to sever was made, when I look at this, the verdict, you won, right? Despite the fact, you won, but you didn't, right? Okay. So despite the fact that this evidence came in about who threw the first slug, okay? The jury said, yep, the defendant was extreme and outrageous, and his behavior was beyond all possible bounds of decency, despite hearing from him that the plaintiff threw the first punch. It's not until you get really down to the nitty-gritty, which seems to me to be an issue of damages, did you prove by a preponderance of the evidence that the extreme and outrageous conduct was severe and of a nature that no reasonable person could be expected to endure it? That doesn't have to do with who threw the first punch, in my opinion. That has to do with how bad was it? Would a reasonable person be expected to endure it? What did they suffer? What did you prove? And you brought in some medical documentation and an ambulance report and some testimony, but nothing more, right?
Yes, there was.
You lost at that prong, not at the prong number 2.
Right, and the appellee is wise to bring that up in the response, that the part on the verdict slip where the plaintiff failed to make his case was his own emotional distress and the severity of it.
Let's just say I believe you. I'm not sure I do, or I agree with you. Not believe, I agree with you that the judge shouldn't have let it in. Okay. So what? You didn't lose on that point. You lost on damages.
Yes, Your Honor, but because the justification or excuse touched on the fundamental aspect of the case, and it would have changed the jury's opinion of the plaintiff.
Why they said the defendant was extreme, right? Look at that.
Yes.
And his behavior was beyond all bounds past all bounds of decency and utterly intolerable. They're on your side.
Yes, Your Honor, but the specific justification or excuse that was offered was that the plaintiff himself was violent. This could have led the jury to believe that this is a pugilist, a rough and tumble figure to whom a fistfight is not necessarily something that's going to cause him severe emotional distress.
But didn't the judge say again and again, you are not to consider whether the force was justified or excused? You need to take as a given, it's been determined already in the criminal trial that it was unjustified and unexcused, so you only need to determine whether he suffered harm, and if so, what amount of damages is sufficient to compensate the plaintiff. So
yeah.
Is your argument dependent on us believing that the jury did not follow the judge's instructions?
To some extent, Your Honor, yes. I would submit that numerous curative instructions are not adequate, and I would cite to Fife v. MBTA for this. Numerous curative instructions are not an adequate remedy if there's been an error of law and it was prejudicial. And that's especially true when the evidence is not withdrawn. The evidence was still in the record. It was not taken out of the record. So even though the jury was told to not consider it, they were allowed to consider it generally.
Well, what element of damage, what element of the battery claim could the question of who threw the first punch to be relevant that the jury was asked to determine?
Well, Your Honor, broadly, I would say that it changed the jury's viewpoint on the entire interaction, that it wasn't a clear-cut assault and battery of one person against another, that this was mutual combat. That could impact damages. I mean, the damage number was $10,000, a nice round number, not perfectly dependent on any one bill. So I do think that the general impact of it, that it had on the jury's view towards the plaintiff, would have played a significant role in damages.
All right, I think we've got your argument, so unless there's anything further you want to say?
No, thank you, Your Honors.
Thank you.
Good afternoon, Justices. Attorney Stephen Delamere for the appellee, Alexander NGUYEN. Justice Walsh, I think you hit the nail on the head. They won. At the trial, there was damages awarded in the amount of $10,000 for $6,500 in medical bills. There was an ambulance ride, there was an emergency room, and there was 2 follow-ups with the primary care physician with no significant findings. In fact, there was no significant findings except for 2 small cuts to the plaintiff's face, which were closed, as I noted, with Durabond. This is not a case of extreme damages upon an assault and battery. This was a case with, albeit not polite and shouldn't have happened, but
extreme and outrageous,
exactly,
beyond the bounds of all human decency.
Yes, and that's what the jury found. And so the jury found that, but they still have to look at the damages in the case to make that determination. And counsel for plaintiff, trial counsel, and I was trial counsel for the defendant, but trial counsel did not object to the court giving these instructions, which they did, if I note, 5 times, at least throughout the record, that the case of battery has already been adjudicated. The verdict slip will tell you, you find any causation for the damages, you are to award the plaintiff damages, which they did. That was done to the veneer, that was done before openings, that was done during the course of the case, it was done after closings, and it was done in the instructions.
So here's a way, I think you heard our questions, and frankly, both of you are doing an excellent job of framing what is an interesting little problem. Here's my, so collateral estoppel applies to facts, right? If a fact has been established, then you have the ability to not have to relitigate that, right?
Yes.
And here, the fact that was established was a lack of justification or excuse for your client's behavior with respect to the battery, right?
Yes.
So, isn't that fact also established for purposes of the intentional infliction of emotional distress claim?
I don't believe so, Justice, because the elements are different. As the trial judge noted.
Elements are different, but collateral estoppel applies to facts.
So in that respect, if we were precluded, my client would not be able to testify as to any fact that occurred that day. We would have to take the plaintiff's version of events as gospel. And the plaintiff, as we've seen, testified as to issues and facts beyond the battery.
Did the plaintiff ask for an instruction that went something like this? You are directed to that it is concluded that the defendant lacked justification or excuse for his behavior.
I don't know if he asked for a specific instruction on it.
If they had, they would have got it, wouldn't they?
I think the court's instructions basically did that by indicating that that has already been adjudicated, and then you just go to damages.
It wasn't done with respect to the intentional infliction of emotional distress claim.
but that claim had to be proved by the plaintiff. The fact is, had the plaintiff only moved forward with the battery, then I think the trial judge would have framed things differently, because the battery now would have just been, that's the only claim we have, that's the only claim that's already established, we're going to damages. The court could have limited the testimony just to the impact of the battery.
No. I take your point that it's a different element, but there's a fact that's been established that's relevant to that element, right? The element is you have to show extreme and outrageous conduct.
Yes.
But one of the facts that's already been established that the jury could have been instructed on is that they lack justification or excuse for their behavior in striking him.
Right, but that doesn't necessarily mean that that's extreme and outrageous.
I agree with that. I agree.
But you lost on that anyhow. I mean.
I did.
Right, you lost. Take the loss, right? Take the loss.
Although the clerk did tell me I won first, and then she retracted it and said, no, wait, that was a yes, and we got through the first 3 elements of the intentional infliction of emotional distress. And again, it's the plaintiff's burden to prove severe emotional distress that no reasonable person could be expected to endure it, and he didn't meet his burden. There was scant testimony about his emotional distress. There was no medical records, psychological records, counseling records of any kind that would have provided the jury with evidence to support that this distress was so severe, beyond the distress of the assault and battery, beyond that he was entitled to additional damages beyond the damages they already awarded, as Judge Davis instructed them. You're not to duplicate the damages. They have to be additional damages. So again, I lost the case, may have won the case based on the amount of damages, but there's no basis here for an appeal. The judge had his discretion to allow that testimony.
At the red brief, I'm not so sure you lost the case, counsel.
Thank you, Your Honor.
Do you see any way in which the question of who started it or who threw the first punch is relevant to the battery claim?
I'd agree. I don't think it's truly relevant, and if it was only a battery claim, I don't think we would even have discussed that issue. But again, in cross-examination of the plaintiff, my duty is to point out things where he is either exaggerating or simply not basically fact-based. Again, he alleged being hit with an object. He alleged being kicked on the ground. Those are elements of assault and battery with a dangerous weapon, which was not adjudicated, which was not even filed, to my understanding. So in that respect, if I allowed that to go in without any cross-examination, then I wouldn't be doing my job. And the fact that my client said, yeah, he threw the first one, I think we also in a battery have to look at mutual combatants. One could be charged with the battery and the other not. And I think in this case, we're also looking at, unfortunately, my client's a 21-year-old physically fit man. The plaintiff was a 54-year-old man, and as a almost 9-year-old man, I don't want to fight a 21-year-old or anyone for that matter. That in and of itself, because an elderly person pushing me doesn't really give me justification to knock him out. We have to look at the parties and see exactly, do we have a David and Goliath situation here, which may lend to, Goliath being charged with the battery and David not. So I think it was just a point of my client testifying to his memory, which was what he told the police, and the plaintiff's attorney had that report to cross-examine if he strayed from it, that while the plaintiff may have thrown something wild to begin with, he certainly was more capable of defending himself, and the result was that, unfortunately, the defendant was injured. But the plaintiff was injured. The plaintiff was compensated for those injuries. I don't believe there's any error or abuse of discretion by the trial judge or prejudicial rights of the plaintiff to require reversal of this case and to send it back for a new trial. It's just not there.
All right, seeing no further questions, we thank you both for your arguments.
Thank you, Justices.
And we will hear the last case of the day, 24P658, Ramanujam versus KANNAN. And I apologize if I mispronounced either of those names. Mr. Barak, whenever you're ready.
Good afternoon. May it please the Court. Matthew Barak for the appellants. We are requesting today that this honorable court vacate all child support provisions contained within the judgment of the lower court, including paragraphs 1 through 5 and part paragraph 10, as void because the Commonwealth lacks subject matter jurisdiction under UIFSA.
How is it UIFSA subject matter jurisdiction? It seems more like personal jurisdiction to me. There's no question that the probate court has jurisdiction over this type of dispute. And what UIFSA comes down to is the particular parties' situations, where they are domiciled, where the children are, whether they have a proceeding going in another state. Why is it subject matter jurisdiction?
Well,
and is there any case saying so?
First, under UIFSA, it creates a framework when there's two completing claims in different states. To your point, there is differing states here. We have New York, we have Massachusetts.
Well, now you're going to lose me, but why don't you answer his question first, and then I'm going to follow up on what you just said.
Okay. If it was as easy as saying, well, we're not going, the probate court just has limitless jurisdiction, you wouldn't have provisions in the UIFSA statute such as home state jurisdiction. So here, it's clear that the home state is New York. And UIFSA limits jurisdiction when there are competing claims under 209D to 204.
Right. But one of those limits has to do with whether the contesting party timely challenges the exercise of jurisdiction in the other state or foreign country, or here. That, I mean, like personal jurisdiction, that sounds like if you don't raise it in time, you can waive it. Why is that subject matter jurisdiction?
It's subject matter jurisdiction because the very essence of custodial issues go hand in hand with custody, and that goes hand in hand with child support. I think that the corollary to your point is if there weren't these limitations, we wouldn't have specific framework that requires the parties to submit the matter depending on the jurisdictional requirements. And the statutory framework, and the statutory framework, if I finish one more thing, the statutory framework is very clear that it talks about jurisdiction of the matter.
Yeah, it uses the word jurisdiction. You're right. Jurisdiction can be personal jurisdiction or it could be subject matter jurisdiction. If it's personal jurisdiction, it's waivable. That's what Judge Sachs is asking about, is whether this word jurisdiction that's in the statute is subject matter jurisdiction. I have another more fundamental question. Why do I care about this statute? Because this statute has a heading, simultaneous proceedings.
Well, first, there are simultaneous proceedings.
No, there were not. Not at the time the judge entered her order. There were not simultaneous proceedings.
Well, I disagree with that because...
Well, what was going on in New York when the judge...
They were fighting about the custodial issues in New York, which goes hand in hand with the child support.
But the child support issue was not in New York, and the reason it was not in New York was because your client said, dismiss the claim because you don't have personal jurisdiction over me. And the court agreed.
That's true.
So why don't we just decide this case, counsel, as it obviously should be as a matter of justice, by saying that 2204 doesn't apply because there weren't simultaneous proceedings, because your client got that not to happen?
Because his conduct cannot confer consent or waive
Subject matter jurisdiction, yes, but the statute has to apply. The statute doesn't apply unless there's simultaneous proceedings.
But I would...
Why would I take a proceeding that doesn't have to do with child support as a simultaneous proceeding? That's your argument, right?
My argument is there were yes, absolutely.
Okay, why would I construe it in that fashion? Simultaneous proceedings presumably has to do with two courts have in front of it the same issue.
The issue of child custody goes hand in hand with child support. And that's why it's labeled as such, and that's why it is, in fact, subject matter jurisdiction.
Judge Bezenius, quite appropriately, in my view, did I mispronounce her name?
It wasn't Bezenius, it was Teixeira.
Oh, was it Teixeira?
It wasn't Bezenius. No.
So Teixeira is the one who said, well, I'm going to dismiss, I'm going to allow the claims for custody and parenting plan to be adjudicated in New York, but adjudicated in New York because, sir, it's a personal jurisdiction problem.
That's not what happened. Where is that in the record?
Where is it? I read it this morning. Maybe I misread it.
There's no in the judgment, there's no I'm talking about the final judgment. the judge the lower court never issued any rationale, never issued any findings, never issued anything.
If I were to find that, that would surprise you.
It would surprise me in the final judgment, yes, the final judgment.
It's not in the final. It's
Okay,
in the earlier decision back in 2019.
We're not contesting that the court had the ability to enter a temporary order for child support. What we don't know is, and this is because Mother raised it and argued it vociferously below regarding subject matter jurisdiction, was that Massachusetts does not have subject matter jurisdiction because of the statutory scheme and the home state being in New York, when I believe there are simultaneous pleadings. But the temporary order does not attach, even if you find that in the record, that there was an explanation as to why there is subject matter jurisdiction in the temporary order stage. The judge below stated to the parties in June, I think, of 2022, or if I may have that date wrong, but she specifically stated to the parties that, look, I'm going to entertain that motion again, which was brought by the wife, and I'm going to make a determination whether there's going to be subject matter jurisdiction in this case. She never did that. And in the ultimate judgment, there are no findings explaining how and why Massachusetts has subject matter jurisdiction. In fact, it does not under this statutory scheme. And there's nothing, I'm going to go back to something Justice Sachs said, because I do. This is not a personal jurisdiction case. This is about subject matter jurisdiction.
Is there any case that says U.S. jurisdiction is subject matter jurisdiction?
Which type
that
of...
U.S. jurisdiction of the kind we're talking about here is subject matter jurisdiction?
I do not know off the top of my head, but if I read the case law, like the Cohen case that's submitted in our reply brief, which deals with child support, it actually does specifically talk about subject matter jurisdiction.
Okay. Well, if you find
So
something...
I'll give you the Cohen v. Cohen case.
Okay. And that... All right. If you find anything else that specifically says from any other state, too, because this is a Uniform Act.
Can I just make sure I understand your argument?
Absolutely.
You argued in New York, don't deal, New York judge, with child support because you can't. Massachusetts deals with child support. You say, no, the New York court should have dealt with child support. How are you not stopped from making that argument now?
Because, first of all, subject matter jurisdiction I don't believe, applies to issues of judicial estoppel. In fact, I couldn't find a single case where a party was stopped under the provision of judicial estoppel when it coincides with subject matter jurisdiction. In addition, the law... Sure.
But I'm missing something. I'm missing a very important link here. It's been a while since I was in law school, but I think I understand subject matter jurisdiction at its basic level. How could the court in Massachusetts, and you're going to say URIFSA or whatever, have no jurisdiction over child support? Because they do, just generally.
As a general provision, they do, subject to UIFSA's limitations when there are competing claims involving the same parties, the same children.
You go to New York and you say, Judge, no, you can't deal with child support here. You got to go back, they've got to go back to Massachusetts.
That was a mistake.
Well,
I wasn't there, but
I'm not blaming you generally.
I'm not saying you are.
Right.
But my review of the record indicates that was clearly
and the judge agrees and says, oh, okay, I won't deal with child support.
You're saying that the argument in New York was a mistake? All right. Well, you said in your reply brief that estoppel doesn't apply when the previous position was based on a good faith mistake. Right. But is there evidence that it was a mistake? Or yes. Are we just supposed to take your word for it?
Well, my supposition is that in the record, the father, the husband, the appellant, below's counsel incorrectly argued the statute.
Okay, your supposition, but I'm asking, is there something in the record from which we can determine that
yes,
that was a mistake?
I would refer you to the argument when the issue of UCC-JE and UCC-JEA, which Massachusetts has not adopted, when I review that record, which is on page 191, 192 of the record appendix. my viewpoint on that is when you read that, the statutes are clearly being inverted below.
This is Volume 1?
Volume 1, 191, 192 of the record appendix.
So,
this was a transcript of the...
it was a motion.
Of the...
Trial hearing.
Right, but this is a transcript of the Massachusetts proceeding.
Correct.
Okay.
am I correct, because I think I'm looking at it, that your client argued in New York that the New York court lacked personal jurisdiction to order child support?
I think I was not in New York, but I think he moved that it was for subject matter jurisdiction there. I think he argued the similar stuff.
Let's assume, just humor me, that actually the motion was made on personal jurisdiction grounds. Wouldn't it be correct that the New York court did not have personal jurisdiction?
No, because I think that's an incorrect reading of UIFSA. I think Massachusetts...
No, the statute can't grant personal jurisdiction.
Yes.
Personal jurisdiction. If personal jurisdiction is lacking, if your client's never been to New York, he hasn't been there, he hasn't taken any steps with respect to the child in New York, I think there'd be a constitutional issue with respect to whether your client could be ordered to pay money by a New York court. I don't know the answer to this question, and I assume it's come up many times before. You may know better than me.
I would agree with you, but that's not the facts of this case.
Well, I disagree with that, because I'm looking at a page from the appendix where I believe someone representing your client said, to the extent deemed relevant, as reflected in the transcript from March 27, 2019, appended to Attorney Watson Fisher's submission, Attorney LaManna misquotes Massachusetts Judge Besenius, who stated on March 27, 2019, personal jurisdiction of you, sir, is in Massachusetts, so the child support needs to be done here. This is in connection, I think, with the motion to dismiss on the grounds of personal jurisdiction filed in New York.
But I think there are in this case personal contacts with New York.
I'm sorry, I missed what you said.
I think there's certainly personal contacts in New York that would have established personal jurisdiction.
Okay. So
because
maybe
and I'll say because the children had been living there since 2017.
Maybe he's been traveling to New York in order to...
Yes, and also the parties stipulated, to your point, they stipulated that the home state of these children were in New York. So there were contacts, and contacts in this...
Well, but that wouldn't be context of the father. But I take your point about that there may be, because of what's happened over the 2-year period. I take that point.
What was the wife supposed to do when the New York court dismissed her child support claim?
I think she did it.
And she needed child support. You were arguing at the time, the husband was arguing at the time, Massachusetts had jurisdiction. What was she supposed to do? Other than come back to Massachusetts and litigate it?
Well, I think Massachusetts could enter a temporary order, which they ultimately, the court did. That's one. Two, she argued, I point out to the court, which I know you know, she vociferously argued that Massachusetts lacked subject matter jurisdiction, being that if it was dismissed, then New York would take jurisdiction over all issues.
But she lost that. That's the order we've been talking about. She lost it. November 2019, the court said, I'm not going to send the child support to New York. She's allowed to take inconsistent positions if she doesn't win them both.
Yes, right? I don't take quibble with that, but at this point, when you read our brief, when you read the appellee's brief, it is subject matter jurisdiction. We both agree, I believe at this point, that Massachusetts lacks subject matter jurisdiction. That was the position that was taken consistently below by the wife.
So you understand how, and the questions from my colleagues, you understand how unjust the result is that you're asking for? Because you're right that if it is subject matter jurisdiction, it can be raised at any time. That it's the court's job to determine its own subject matter jurisdiction. So then we're left with a situation where you asked for it to be dropped in New York, tried the case here in Massachusetts, The result is what it is, and now you want that thrown out because that court lacked jurisdiction.
And my response is, you have it 100% correct. However, what would happen as a family law practitioner is just going to go back to New York, where the guidelines are slightly different, where there's going to be retro, and it's just going to be adjudicated in the appropriate and proper form. I think, in other words, you're worried about an injustice here because of what happened below. One, that doesn't change the fact that Massachusetts lacks subject matter jurisdiction, in my opinion.
Well, I don't see the wife's brief agreeing that UIFSA is subject matter jurisdiction.
Well, I think if you read it, she talks about that that's what they argued correctly below, 1 point, and 2, that really the brief on that point deals with the issue of waiver, which you cannot waive subject matter jurisdiction. So I do think, to your point, Justice Engler, this would go back, and New York would make a new order regarding the child support that would likely...
Would it be appropriate for the New York court to award all the fees that the mother has incurred in having to go through a trial on that issue that she's now been told lacked subject matter jurisdiction?
I think that's up to the New York court to make that determination, and under child support provision it would. And I would just point out...
Would you oppose it?
I'm not a New York attorney, so I don't want to speak to that, but I would say that that would be an issue for the New York courts to determine. And I think if the reverse was true in Massachusetts, I think it would be adjudicated as well in Massachusetts the same way. I submit on my briefs if there's nothing further. And I will cite the Cohen case and a few others if that's by letter.
Thank you. All right, we'll hear from counsel for the mother, Ms. Attorney Lamanna.
Good afternoon. If it may please the court, I am Jennifer Lamanna, and I represent ANUSHA KANNAN in this matter. The Massachusetts courts have consistently held that subject matter jurisdiction is a court's ability to hear a particular category or particular type of case. VM versus RB made that very clear, and it cited a long line of case law, including Doe. There's no way around that.
I wish, I appreciate very much you citing that case. You might have noticed who was on that panel.
I saw your name there, Your Honor.
But I really wish it were true that we've been very consistent about jurisdiction. That I'm not sure I can agree with you on.
Well, that case is consistent with the position I'd like you to take today.
There we go.
I'm happy to say that. I think it's important to note that contrary to what my brothers just argued, my brief does not concede that this is a subject matter jurisdiction. In fact, that's the focus of my brief, is that it's not a subject matter jurisdiction, and I don't dispute. I took a different position in the lower court. I was arguing that it was a subject matter jurisdiction point. I was wrong. It was not. It was a personal jurisdiction point. Judge Basinius announced at the very first hearing in June of 2019, child support will be done here because father is here. And my initial response to that on the transcript was, we're fine with that. And then I went back and looked at the pleadings and realized there was no actual claim for child support pending in Massachusetts. Father hadn't sought any orders of child support, so we amended the mother's counterclaim at that time in order to raise a claim for child support. We then, after consultation with New York counsel, realized under the UIFSA, as we've been referring to it, that it really should be New York that should handle it, given that the children had been there, et cetera. So we withdrew. I had a right to voluntarily dismiss at that time my pleading, and I did, and mother filed in New York. Now, one of the questions that was asked of my brother a moment ago was whether father argued in New York that it was a personal jurisdiction issue. He certainly did. It's in the supplemental appendix at page 18. I quote it directly, and what father argued was, in Massachusetts, the respondent father has not and does not consent to New York jurisdiction over child support. He has not generally appeared in a New York child support matter except to contest jurisdiction over support. He absolutely contested the personal jurisdiction, and I believe it was Justice Sachs who noted one of the first things that jump out at you when you're reading the simultaneous proceedings provisions is the fact that if a party has timely raised an objection to jurisdiction, timely waivers do not apply, timely objections don't apply to subject matter jurisdiction cases. I hunted because given that the appellant here based their claim on the idea that this was a subject matter jurisdiction case, I was very troubled when I read the brief that there was not an ounce of authority cited to support that proposition. And if you're looking at the VB case and the Doe case that it cites heavily from, it comes back to the idea that in Massachusetts, the question is whether or not the tribunal has the ability, the authority to hear that particular type of case, and it cannot rationally be argued that the probate and family court in Massachusetts does not have the authority, a legislative grant, to handle child support cases. Now, Justice Englander, you noted that 2204, by the time we got to trial, was really not the thing we needed to be talking about anymore, because 2204 is an attempt by statute to prevent multiple orders issuing in different jurisdictions when there are simultaneous proceedings. But by the time we got to trial, by father's, in my opinion, utter misrepresentations as to the facts of what had gone on in Massachusetts, but based upon that, by the time we got to trial, there were no longer simultaneous proceedings in Massachusetts and New York as to child support. Now, New York specifically,
Why don't we just leave it at, father took the position in New York that they didn't have personal jurisdiction over him. Case had been dismissed in New York as of the time you started trial.
Not once, but twice, that's correct.
So why would 2204 apply?
It doesn't. 2204 is no longer the issue, because 2204 is a way to deal with competing jurisdictions with simultaneous proceedings.
It reads like to me.
I see that the caption of 2204 says simultaneous proceedings, but I don't see that in the body of the statute, and usually we don't treat captions as controlling over the language.
I'm going to interrupt here. So in the version of the statute that I looked at this morning, it is in the body.
Okay.
In the version of the statute that I have sitting here on my desk, it is not. So we're going to have to figure
All
that
right.
out.
Yeah, we'll go back and look at the acts and resolves and
The
see.
first two words of 2204 actually are simultaneous proceedings.
All right.
And it does consistently, 2204 is all about where a tribunal of the Commonwealth may exercise jurisdiction, and it goes on and on about if the petition or comparable pleading is filed after a pleading is filed in another state, and then it goes into this discussion about how do we decide which state gets to do it. The problem here, of course, is that father successfully argued in New York. Massachusetts is handling this, even though Massachusetts wasn't. Massachusetts pleadings have been filed, even though they had been withdrawn at the time he made that argument. And he prevailed on that argument that you don't have personal jurisdiction over me in New York, and Massachusetts has already exercised jurisdiction over this issue.
So if we accept your argument, it's personal jurisdiction, I understand the rest of your position. If we accept counsel's position that it's subject matter jurisdiction, what's your response, if any?
If it's subject matter jurisdiction, I don't dispute the fact that it's not waivable.
Right.
Would it be an injustice? Yes. Should my client get fees from somebody somewhere? Absolutely. But I don't concede that it's subject matter jurisdiction
No,
at
I
all.
understand. I just wondered if you had anything.
No, I searched far and wide, and if it's subject matter jurisdiction, you can...
Yeah, the reason for that is obvious, right? If the court doesn't have the power to make a decision, it never had the power to make a decision.
Right.
But that's why we have to be very careful, and I appreciated your brief, about what we call subject matter jurisdiction. And sometimes we use the word jurisdiction and we don't use it correctly.
And I think it was you, Justice Englander, who specifically asked, and I apologize if I'm giving credit in the wrong place, but where in the UFSA does it mention subject matter jurisdiction? It does not. It uses the word jurisdiction. The word may appears a lot. In the commentary to the UFSA, they talk about priority is given to the children's home state. There are many reasons for that. Largely because child support is based on a particular state's guidelines, based upon their cost of living and matters like that. And so it seems appropriate, and which is why father fought so hard. In New York, mother would have gotten more support than she got in Massachusetts. So father fought very, very hard to make sure he got the lower support order in Massachusetts.
Are you saying you did research on the word jurisdiction in 2204?
I've done...
Whether or not that was subject matter jurisdiction?
I could not find a single case that said specifically that UIFSA jurisdiction was subject matter jurisdiction. And I could not find any case in certainly no case in Massachusetts that said that. And then, of course, I found the cases we've already discussed that say, at least for Massachusetts purposes, when we're talking about subject matter jurisdiction, we're talking about a court's ability to hear a particular type of case.
Power.
The power.
Power to adjudicate a particular type of case. But the problem is that word jurisdiction, as it's used in 2204, I mean, Judge Sachs has suggested it might mean personal jurisdiction, but the word's there. And yeah, I'm really not sure what to do with that. I'm more concerned about whether or not the statute even applies under these circumstances.
I would say that it does not, for the reasons that you noted, that at the time that the court...
And it
was
doesn't,
making-
once you assume that you're going to trial at a time when there's no proceeding going on in New York, then these other parts of 2204 don't make any sense anymore. Like, I wouldn't know how to apply it because there is no other filing to be concerned about, right? I mean, if you look at like the three... I don't have it in front of me at the moment, but it doesn't seem to be speaking to a circumstance unless there are two proceedings going on.
It specifically addresses very, very clearly what those are. If the petition is filed before the expiration date, if it's all about...
So what do you say to your brother's argument that there was another proceeding going on in New York because there was a proceeding with respect to the children's custody and parenting plan?
I think that's no more relevant than if my client had a breach of contract action also pending in New York. Because New York specifically, and my brother, I believe, would be aware of this if he reviewed the pleadings that were filed in this case, New York treats child support and custody as two separate complaints. In Massachusetts, you can file one big complaint asking for custody, child support, et cetera. In New York, it's two different tribunals.
So when the New York court dismissed the claim for child support, was that appealable?
It certainly was. It certainly was.
Immediately, didn't have to wait for issues
That's right. It
of...
was a final judgment. It was a final judgment. So the way the New York
So-
court is set up,
So the wife could have appealed that.
could have. She could have. She pursued
How should
here-
we take that into account?
You could certainly take that into account.
Well, how?
How should you take that into account?
Yeah.
Well, she had no obligation to continue to pursue that. She was allowed to take the L, so to speak, and say, all right, New York is not, she tried twice. We filed very substantial
It was dismissed on a
pleadings.
procedural ground. It wasn't dismissed on the merits.
It was dismissed on procedural grounds.
Jurisdiction.
On the ground, well, it was actually, I would suggest, dismissed without an evidentiary hearing based on father's misrepresentations as to what was occurring in Massachusetts. But-
Dismissed without prejudice?
Pardon me?
Dismissed without prejudice?
It was dismissed without prejudice, and then we filed it again. Well, we did not file it. Her New York counsel filed it again. We also filed a single justice appeal attempting to address the fact that Massachusetts would not address these arguments. But one of the issues, of course, is that the father, throughout his pleadings, tried to consistently wanted to separate the issues of custody and child support, and he was successful doing that, but now on appeal wants to say they're combined for purposes of the simultaneous proceedings part. But the UCCJA and the UIFSA are very different statutes with significantly different terms because they deal with two different types of proceedings, custody and child support. It's not all the same procedure.
Can I just interrupt for a moment before I lose this thought? If your position, if we agree with your position, you agree that because Kavanaugh wasn't applied, it should be remanded?
Just as to that paragraph with regard to the 23% of your begint, just that paragraph. The judge was very clear in terms of the other paragraphs that it was additional child support.
So what about the 23% on the bonus?
23% on the bonus, I don't think the Wasson case, which is cited by the father, applies here. The Wasson case was a situation where the judge, without any indication of why she was doing so, excluded capital gains income from a child support calculation, and the court very correctly found you can't do that.
But is it consistent with the guidelines to award sort of an open-ended 23% of any bonus?
It is not only consistent with the guidelines, it is consistent with regular practice in the probate and family court, which is to take, to run.
Let's not go there for a moment.
Okay.
I thought, so I'm, color me potentially ignorant about this, but I knew, because what's worse is I knew something at one time. There used to be a cap. Once you got to $250,000, the guidelines stopped operating, right? Has the cap been removed?
The cap is, well, certainly at the time that this was done, the cap had not been removed. It's still there. It's still basically,
Okay,
there's
so
this presumption
in order
up to
that says
400 grand.
23% of any bonus, you're reading into that then. In order to claim that it's not, that it's consistent with the guidelines, you're reading into it a limitation that 23% can't go over the cap.
Well, the cap is not, the issue with the cap and the guidelines is that after over 400,000, it's discretionary. It's not mandatory.
There need to
You
be
cannot-
findings.
Yes.
But there would need to be
specific
findings, which weren't made here
If it's
to
over
go over
400.
the cap.
I don't think there's any indication in this case that these people's combined income, even with bonuses, ever exceeded 23.
No, I don't think there is
excuse me,
either,
ever
and that, I
exceeded
didn't know the
400,000.
cap.
But
So
it
it was
is
250 when I recall it, so.
Yes, it's 400 now. Combined incomes of the parties, it's 400 now. And after that, it is discretionary from the court. The court can make specific findings and determine what support is necessary. Certainly, there are many, many people in Massachusetts whose combined incomes far exceed 400,000, and child support is not limited to the amount, to that amount.
Where does the 23% come from? I know that's the amount applied to his ordinary income.
I think that's exactly where it came from, which is also very consistent with practice, is to say the percentage of the father's income that is being assessed for child support it's appropriate to carry that over. I have certainly argued and heard argument where some judges just do a blanket percentage. Every time you go in front of them, it's 25% or it's 28%, depending on whether it's pre or after, pre-tax or post. But it's also very consistent to say, I'm going to use the same percentage. The same percentages, because the guidelines, when you run them, are consistently taking child support expenses, child daycare expenses and health insurance expenses and assigning things based on percentages of each party's income. I think it's perfectly appropriate for the court to have done that here as to the bonus income. But I don't dispute that as to, she did not add that phrase as additional child support in that paragraph about Yorba Gant, and certainly I can't pretend to know what her intentions were as to that.
Okay. Seeing no further questions, we thank you both for your arguments.
Thank you.
That concludes this very long day. I want to thank our court officers, law clerks, and other court staff for their assistance, and with that, we are adjourned.
Thanks to both of you for keeping us so energized on the last argument. Well done.